英文 testing 1 2 3 testing 1 2 3英文 testing 1 2 3 testing 1 2 3 testing 1 2 3 hello 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 testing 1 2 3 testing 1 2 3 hello testing 1 2 3 hello Hello testing 1 2 3 Hello 1 2 3英文 testing 1 2 3 Hello testing 1 2 3 Hello 1 2 3
嗰個試聽獎我冇俾你啊？
咩啊？
有
俾咗啦。
testing 1 2 3英文
講英文我下晝有場。
testing 1 2 3英文 Hello 1 2 3 1 2 3 testing 1 2 3英文 testing 1 2 3 Hello testing 1 2 3 Hello 1 2 3
Moderator
testing 英文 1 2 3 testing 1 2 3呢個英文 testing 1 2 3 1 2 testing 1 2 3 testing 1 2 1 2呢個英文 1 2 3 testing 1 2 3英文 1 2 3 testing 1 2 3呢個英文 testing 1 2
有
3
moderator 叫你咩啊 ？Robert Lee。
Hello testing 1 2 1 2
肇係肇慶走個肇，強健嘅強。
英文呢個
一樣嘅，方向一樣嘅。
最先冇事啊，應該我調轉咗個頭之後咧，冇一條線唔關事嘅，另外即刻嚟。
係咪維持個維啊？
或者佢嘅翻譯史為中，歷史嘅史。
testing 1 2 3英文 1 2 3
間唔中我你
唔緊要，
轉一轉 RC 啊，係啊，我可以試到噶啦，我哋即刻。
咦，好嘅。誒，阿豪仔幫我噏兩句。
testing 1 2 3英文 1 2 3
我試先嚇，等陣間。最緊要搞掂。
係啊，最緊要搞掂。如果唔係啊，做後期好煩㗎，你知我哋啦，做後期。
梗係知啦。等先，我換條線先。好啦。英文，我換咗佢咯。
呢條橙色冇問題嘅，應該 EV 聲我哋嘅。
係啊，我知道，佢勾過去嗰邊嘅嘛。
唔勾過嚟。
係不嬲就係咁。好，你聽下。我睇下係咪而家換咗條線，睇下會好啲。
好，講英文。
好 testing 1 2 1 2呢個英文 1 2 3 testing 1 2 3 1 2 hello testing 1 2 3呢個英文 1 2 3 testing 1 2 1 2 1 2 3 testing 1 2 3呢個英文 testing 1 2 1 2 testing 1 2 3 1 2 3呢個英文是咪 1 2 1 2 testing 1 2 3 1 2 3
Hello, ladies and gentlemen. Welcome back to the afternoon section of International Criminal Law Conference. Just a wrong reminder, because one of the speakers will conduct his presentation in 普通話. If you need the simultaneous interpretation in Cantonese or English, please feel free to borrow a headset from the reception. 咁我哋今日嘅活動咧，主要會以英語進行嘅，咁而個別咧有嘉賓講者會以普通話進行。如果需要即時傳譯服務嘅嘉賓，可以去到接待處借取耳機。我哋今日分別提供英語、廣東話同埋普通話嘅選擇。我們今天的活動主要以英語進行，個別的嘉賓以普通話進行。如果需要即時傳譯服務的嘉賓，可以到接待處借取耳機。謝謝各位。 Good afternoon, ladies.
女士们、先生们，下午好，欢迎来到下午的环节。这次呢，马上要开始了，请就坐。
If you need simultaneous interpretation in English or Cantonese, please feel free to borrow a headset from the reception. 咁我哋今日嘅活動咧，主要以英語進行。
Today's event is conducted in English. If you want simultaneous interpretation into in English, 普通話 and Cantonese, you can get a headset from the receiver. 我哋今日咧係主要係英語進行，如果需要傳譯服務嘅嘉賓咧，可以喺接待處咧係借個耳機。多謝各位。
Hello, ladies and
女士们、先生们，欢迎我们第二天香港法律周2021
Law Conference. I'm so happy to see you again. Good afternoon. 大家好，大家好。So I hope some big hands. Maybe we can have some big hands to kickstart our afternoon. Thank you. In the afternoon program, we have another two panel section. For the upcoming program, the panel section 3 on combating corruption in the mainland and Hong Kong, we are pleased to have Mr. Robert Lee SC as our moderator. Mr. Lee is a practicing barrister in Hong Kong and practiced criminal law for over 20 years. Apart from legal practice, he maintains a keen interest in jurisprudential reflections on the common law and draws insights from classical Chinese philosophy and Popperian critical rationalism. So now let's give the stage to Mr. Lee.
Thank you, Ms. Leung. Ladies and gentlemen, it is my great pleasure to welcome you all to this afternoon session on the topic of combating corruption in the mainland and Hong Kong. Corruption threatens the rule of law, as it is the rule of law which maintains fairness and social progress. We should rightly be concerned with the fight against corruption. We have three very distinguished speakers to share with us on this important topic. The first is Mr. Shi Wai-jung of the Supreme People's Procuratorate. Due to health situation, Ms. Shi will speak from Beijing through a recorded video. Our next speaker is the well-known Mr. Simon Pei, the Commissioner of the ICAC. The last speaker is Mr. William Tam, SC, of the Department of Justice. I will say a few more words about these distinguished speakers later. The time allotted to this session is 90 minutes. Each speaker will speak for about 20 to 30 minutes. And near the end of the session, the speakers will reflect further on the topic, if time permits. Now, we will begin with our session with Mr. Shi Wai-jung. Mr. Shi holds a PhD in law. He is a member of the Procuratorial Committee and Director General of the Third Procuratorial Department, responsible for duty-related crimes of the Supreme People's Procuratorate of the People's Republic of China. So Ms. Shi, you may think, is very experienced public prosecutor who holds a strategic mainland position in the fight against corruption. Mr. Shi speaks in Putonghua. As mentioned by Ms. Leung, simultaneous interpretation of his speech into Cantonese, Mandarin, and English are available. Just use the headphone and switch to the right channel. You would appreciate that the mainland's continental system differs from the common law system in many aspects. With that contrast, you may find Mr. Shi's speech informative, challenging, and also rewarding. Mr. Shi's recorded video covers three areas. The first is on the division of functions between key institutions, including the National Supervisory Commission, 国家监察委员会, the Procuratorate, 人民检察院, the law enforcement agencies, 执法部门, and the courts, 审判机关. The second area is on procedures, including enforcement and trial procedures. The third area is on certain areas of concern, including the pursuit of fugitive offenders and confiscation of crime proceeds. Let's welcome Mr. Shi.
Ladies and gentlemen, good afternoon to all the guests and experts. Thank you very much to the organizer and the invitation of the Secretary of Justice. I'm very pleased to attend this International Criminal Law Seminar and to give a presentation on the basic information about the anti-corruption work of the named prosecution authorities. Since the 19th National Congress of the CPC, the prosecutorial officers adhere to the Xi Jinping's thought of socialism with Chinese characteristics in new era as a guideline, resolutely implement the national anti-corruption work of the decisions and deployments, conscientiously implement the constitution and laws, actively participate in the reform of the national monetary system, and punish on duty crimes. It has played an active role in the process of the overwhelming victory in China's anti-corruption struggle. Allow me to introduce the following three aspects. Number one, the institutional mechanism of China's anti-corruption work and the related functions of the prosecutorial officers. CPC and the Chinese government have always attached great importance to anti-corruption work. They have continuously improved the institutional mechanism of social anti-corruption work with Chinese characteristics, which has provided strong guarantee for the long-term stability and sustainable development of the country. First, the centralized government and unified leadership of the CPC Central Committee on Anti-Corruption Work and fights against all forms of corruption with the determination will get to the point. It has become the most powerful political leadership and guarantee to fight corruption. And the second is to insist on anti-corruption of all kinds of zero tolerance and to promote the overwhelming victory of the fight against corruption. It is comprehensive consolidation. And then thirdly, to adhere to the people as a center, resolutely punish the corruption and malpractices that occur around the people. And according to the statistics, the satisfaction rate of the people with anti-corruption work reached 95.8%. Number four is to adhere to the rule of law and the approach together to promote the strategic goal of not daring to corrupt and not wanting to corrupt. To deepen further the reform of the discipline, inspection, and supervision system, prosecutorial committees of all levels have been established and the centralized, unified, and a comprehensive coverage of an authority and efficient supervision system has been set up, and the coherent integration of inter-part supervision and various means. And it should be also noted that the first meeting of the 13th National People's Congress adopted the amendment to the Constitution of the PRC on March 11, 2018, and the PRC supervision was also adopted on March 20th. The nature and status of national supervisory commissions and local supervisory commissions are clearly defined with all relevant personnel, etc., forming the leadership with the anti-corruption.
This has become an anti-corruption work institution with Chinese characteristics. So for suspected disciplinary and criminal violations of the public officials, inspection, investigation, and disposal is to be carried out. The National Supervisory Commission has also announced on the 20th of September 2021 the implementation of the PRC supervision law, which further standardized the duties and powers of the supervisory authority. This has perfected legal procedures for the execution power. The People's Procuratorate is the legal supervision office of the state. After the reform of the state supervision system, the main functions of the office involved in anti-corruption work are as follows. First, to perform early intervention in housing cases and criminal detention, arrest, review, and additional investigation, prosecution review, to also all the way to court appearance to support the public prosecution, trial supervision, and other functions. Second, the discovery of litigation activities of the judicial staff for suspected crime of illegal detention and illegal search, confession, extortion under torture, crime of violence to obtain of evidence, and ill treatment of persons under supervision, abuse of power or direction of duty, or crime of favoritism, and so on and so forth. Formal malpractice, reduction of sentence, and also parole, provisional release from prison, etc. So a total of 14 crimes of violating the rights of citizens to would also be looked into. Well, for the first 9 months in 2021, a total of 1,840 cases of related crimes were set up and investigated into, and we also worked with the supervisory officers so that there be check and balances. under Article 127, Paragraph 2 of our Constitution, and also Article 4, Paragraph 2 of the Supervision Law, which clearly stipulate that in handling such cases of violations and so on, the supervisory officers should coordinate with the enforcement agencies so that we'd be working together in order to exercise checks and balances. Regarding the national procuratorial officers transferring duty cases to these different levels of committees, 19,760 people were referred to for prosecution in 2020, 15,346 people were prosecuted, and 662 people were released without prosecution. In 2018, the Supreme People's Procuratorate carried out internal reform. A huge framework of 10 businesses and 4 major supervision was set up, including the criminal and civil and administrative public interest litigation. And one of the special and important businesses is the work of the prosecution of job-related crimes. For this reason, the Supreme People's Procuratorate has set up a third procuratorial office, which is the Office of the Procuratorate of Official Crimes, specifically dedicated for improving the work. The provincial procuratorates have also set up corresponding departments accordingly. So other local procuratorates have also set up relevant agencies in order to look into the local situation, assisted with special team of prosecutors responsible for arrest and so on. Secondly, the main approach of the procuratorate officers was to perform procuratorial function on job-related crimes. So we will have to act in accordance with our duties to conduct arrest and so on. According to Article 169, 170 of the Crime Procedure Law, the People's Procuratorate for the transfer the People's Procuratorate is responsible for transferring cases from the supervisory officers in accordance with the provisions of the first paragraph of Article 47 of the Supervision Law to review and arrest in accordance with the law, and review and prosecute the cases. We have to look at cases whereby detention has taken place, and also we would also be looking at the defendants, and the decision will be taken to detain the suspect. And after the investigation, after we have looked at the relevant circumstances, a decision will be taken as to what action will be taken. And if the review shows that there is sufficient evidence, then the relevant parties will have to take up the responsibilities, and therefore a decision to prosecute will be taken. Or else you will have to report it to the supervisory level of a procuratorate so that action will be taken accordingly. And if a decision to prosecute is taken, in other words, after the application by the procuratorate, the People's Procuratorate can also send people to look into the case, and they can also verify the facts, and then they would also give written comments. And after receiving the People's Procurator's opinion of whether the intervention supervisory office should conduct a timely review, and if additional details are necessary, they should offer the feedback to the People's Procuratorate so that they can be submitted on time. Thirdly, to conduct serious supplementary evidence or to provide such evidence after the case is transferred for review and prosecution. If it is necessary for additional evidence to be adduced, then they would also conduct additional investigation, and the investigating authorities are requested to provide evidence and materials necessary for trials so that all facts are clear and the evidence is sufficient. Fourth, the prosecution of omitted crimes and offenses. The procuratorial authorities may, after discussion with the relevant agencies, prosecute directly if omitted crimes based on the existing evidence are found during the review. If additional verification is needed for the omitted crimes, the case may be returned to the supervisory officers for additional investigation. It can also be studied by the procuratorial officers after additional transfer to the procuratorial officers for prosecution. Fifth, court appearance to support the public prosecution and trial supervision. The People's Procuratorate can delegate officers or deploy officers as the state public prosecutor for the official crime to support public prosecution, and also to supervise if any violation of the trial together with any correction for the judgment occurred for the relevant case. And if there is any incorrect judgment found, then appropriate objection should also be taken. So rectification should also be taken. So if there is a judgment that the judgment has been incorrectly made, then remedial work will have to be done. 6, we will also have to do appropriate work for leniency at the legal and political systems. According to the provisions of the criminal procedure law, if the suspect defendant voluntarily and truthfully confess their crimes and admit to the alleged criminal facts, then that can be dealt with leniency. The Supreme People's Procuratorate, together with the Supreme People's Court and other departments, have jointly issued guidelines on the application of the leniency system of the securities law. According to the statistics, the number of cases applying for leniency in the National Procuratory offices have accounted for some 73.3% of the total number of completed cases of examination and prosecution. 7, we have to strengthen and standardize the construction of the legal system, together with the Supreme People's Court and other departments on the handling of criminal cases of corruption and bribery. We have jointly agreed that there should be a standardized interpretation of the applicable laws. This will further unify the standards of law enforcement and justice. The development will also ensure that there will be common standards, and that would also be more effective in preventing such crimes. We have also set up a regular notification system, and we will also be analyzing the case together so that we'll be able to provide professional guidance so that we'd be able to work more effectively, and that is also to ensure that there will be high quality of trial and prosecution. The third situation that I'd like to report to you is that there are several highlights of work within my office. First, we have to proactively confiscate illegal proceeds and also trials in absentia, in order to cut off the capital chain of fugitives and to maximize the recovery of state laws. In 2018, we have introduced newly revised criminal procedure law provisions so that for corruption cases, and if the suspect absconds or dies, or if he has absconded and gone abroad, then the People's Procuratorate may apply to the People's Court for confiscation of illegal proceeds and also conduct trial in absentia. In 2020, the procuratorial authorities have initiated the procedure for confiscation of illegal proceeds of 7 of corruption or bribery suspects who have fled or died. A red alert was issued to the chairman of Yugang Group, that is Chen Shangchang, so that a wanted person notification was issued, and that was done through the Interpol, and he has fled overseas. The court was also recommended to prosecute him in absentia, and that has also achieved a significant effect. In addition, significant work was also achieved by procuratorial agencies by cooperating with United Nations Convention Against Corruption. And we have also joined in the anti-money laundering work. In 2020, the Amendment 11 of the criminal law has also modified the constituent elements of the money laundering regime, so that for corruption and bribery proceeds, we have also provided a legal basis for that, so that we'd be able to further deal with such crimes. And the Supreme People's Procuratorate and the provincial People's Procuratories have also established anti-money laundering task force to coordinate on money laundering investigation. Procuratorates at all levels have also established a mechanism of double investigation of a single case. In other words, when handling cases of upstream corruption and bribery and other 7 types of crimes, there is simultaneous review on the possibility of money laundering. For those that constitute crimes under the law, public prosecution will conduct investigation promptly. The suspected leads found are transferred to the relevant agencies for handling. Classic case studies are also published jointly by the Supreme People's Procuratorate and the People's Bank of China. From January to September 2021, a total of for people who have concealed their corruption proceeds and so on, 14,811 people were indicted by the country's wise procuratorial office, which was up 2.8 times year on year. Among them, 580 people were convicted for the crime of money laundering, up 81.8% year on year. At the same time, immediate analysis are conducted for those agencies found in the documents on issues of any management deficiency or lack of penalty and so on. Recommendations are also sent to the management of the financial institutions and to guide the regulatory departments to close the management loopholes. This will improve the working mechanism system to prevent recurrence of similar problems. Number 3, to consolidate criminal justice policy and also to ensure that we will carry out arrest appropriately for private entrepreneurs suspected of bribery. We will also have to adopt a lenient approach in dealing with such cases so that whenever there is a chance that we don't have to take up prosecution, then we will also have to do so. And suspended sentences can also be imposed where the suspect is willing to get back to normal practices and so on. And we are insisting on promoting enterprises so that they would work in accordance with law and they will become law-abiding, and that would also help reduce business crimes. And we would also try to have a good impact on businesses and promote law-abiding and compliant operation. We will also look at the suspects and for enterprises that are operating regularly, they would not be closed off and they would also not be sealed. They would not be having their property or assets confiscated, except for certain illegal assets and so on. And therefore, for the suspects' property and also their family members' assets, so we will only be confiscating them or seizing them or freezing them if it's found if there are valid grounds. And we will also be adopting a two-pronged approach. Well, on the 25th of February 2021, President Xi Jinping solemnly proclaimed that China has already achieved a comprehensive victory in the fight against poverty. It has completed the arduous task of eliminating abject poverty. It has created another human miracle that has made history. In order to effectively consolidate the results of poverty eradication connecting to rural revitalization strategy, the procuratorial officers at all levels collaborate with the discipline inspection and supervision officers in accordance with the law to publish or to punish those corrupted criminals infringing on the vital interests of the general mass, such as embezzlement and misappropriation of funds for poverty alleviation, agricultural relief, and disaster relief. To seriously implement poverty alleviation work, a fast return of the property involved is necessary, and therefore we will have to carry out a very careful review on the determination of ownership, and therefore for those who have had their properties infringed upon, they will also have the properties returned. And some 5 cases have been announced so that they would form the case laws, and we would also provide legal relief in order to help fight this. So we will have to act in accordance with the law in order to make sure that appropriate action is taken. And we will also have to ensure that there will be technology innovation, because in order to ensure that we will enjoy long-term development, then we will have to promote the development of technical innovation and development. And therefore, we will have to ensure that we will act in accordance with the law to prudently handle non-standard use of funds. And we will have to supervise on the use of such funds, and for any unauthorized use or appropriation of funds, and also for major scientific research activities in case of office crimes and so on. We will have to make sure that we will carry out arrest, and that has to be vetted by the provincial procuratorate for approval. In September 2021, the Supreme People's Procuratorate has also compiled a number of case studies on R&D staff involved in illegal research funds, and clear guidance is provided from the case studies for the limit and relevant work requirement. This will help junior agencies to properly handle similar cases. As we know, corruption is the common enemy of humankind, and therefore we will have to work together to deal with this problem.
中国检察机关愿与各国
We are willing to cooperate with all the people to have this common human destiny community of mankind, building together a home connected to the beautiful landscape. This is the end of my presentation. Thank you very much.
谢谢史先生。Well, our next speaker, Mr. Simon Pei, should be well known to you all. Ms. Pei has a distinguished career in the civil service before becoming the commissioner of the ICAC. He joined the Immigration Department in 1978 after graduation from Chinese University of Hong Kong. While in service, he was selected to attend advanced courses, including those on public policy and administration at the Graduate School of Public Policy at UC Berkeley, and courses at the Royal College of Defense in London. He was also awarded a master's degree in international relations by King's College London. He was appointed Director of Immigration in 2008 and retired in 2011. On the 1st of July 2012, Mr. Pei was appointed by the Central People's Government to his current position, the Commissioner of the ICAC. Mr. Pei's distinguished public service was well recognized by the government. He was awarded the Immigration Distinguished Service Medal and the Silver Bohemian Star Medal in 2006 and 2011, respectively. With such a distinguished background, Mr. Pei will speak about the contributions of that legendary institution, the ICAC, and examine the components of the anti-corruption regime in Hong Kong. He will also look at new developments in the anti-corruption field and comment on the misconceptions of some foreign stakeholders. Let us welcome Mr. Pei.
Good afternoon, ladies and gentlemen. First of all, I would like to thank the Department of Justice for inviting me to speak in this high-powered conference. It gives me great pleasure to share with distinguished delegates, both locally and abroad, the requisite components of the robust anti-corruption regime of Hong Kong. I would also like to take this opportunity to address some of the major issues of concern and developments in the international anti-corruption arena, and demonstrate how Hong Kong tackles these issues effectively within our anti-corruption framework. The Independent Commission Against Corruption, ICAC in short, was established in 1974 as an institutional response to the rampant and seemingly intractable corruption in Hong Kong at that time, by adopting an innovative three-pronged strategy of law enforcement, systemic prevention, and public education. After only about 20 years of dedicated efforts, and with the support of the government and the local populace, corruption was basically under control since the 1990s. Some people said this was a miracle, as similar results was not seen in many places across the globe, even with our laws, systems, and practices copied there. It also reflects that curbing corruption relies on many other factors, which I will elaborate some of them later on. Hong Kong now has a clean environment and an effective anti-corruption system, which uphold our city's status as an international financial center, a vibrant service hub, and well-connected capital for global trade. Hong Kong's clean environment is both locally and internationally recognized. For example, the Corruption Perception Index 2020 of the Transparency International, TI in short, ranked Hong Kong the 11th least corrupt place among 180 territories around the world. The Rule of Law Index 2021, released by the World Justice Project just last month, rated Hong Kong the 9th among 139 places across the globe in terms of absence of corruption. The perceptions, and more importantly, the actual daily experience of the people of Hong Kong are also consistent with these international rankings. According to the ICAC Annual Survey 2020, carried out by an independent survey agency, 98.4% of the survey respondents indicated that they had not encountered corruption personally in the past 12 months. 93.2% of them said that ICAC deserves their support, and 98% consider that keeping Hong Kong corruption-free is important to the overall development of our city. These findings prove that integrity has become a social culture, a consensus, and more importantly, a core value deeply entrenched in the hearts of Hong Kong people, thanks to the almost 48 years of public education. The number of corruption complaints relating to the government sector records a substantial decrease from about 27,000 in 1974 to an average of less than 700 in the recent 2 years. As epitomized by a number of global competitiveness rankings, including those compiled by the International Institute for Management Development and the World Economic Forum, Hong Kong is one of the most competitive economies around the world, where businesses can thrive on clean deals in a fair and open market. I read from a newspaper this morning, there is the latest survey on foreign companies asking them why you choose to do business in Hong Kong. So again, in a line, clean government is one of the top 3 reasons set by them. So you can see how important is a clean society and a clean government to business. So what are the requisite components of the robust anti-corruption regime in Hong Kong? Let me highlight some important ones. The first and foremost component is the government's unwavering determination in stamping out corruption. No one will doubt the resolve of our government, now and then, to eradicate corruption. Translate it into concrete policy measures. This strong determination includes, firstly, proactive support at the highest echelon of the government by, for example, allocating adequate resources to the ICAC. Secondly, the executive branch strictly adheres to a non-interference stance in relation to the work of the ICAC. Thirdly, policy bureaus and departments actively collaborate with the ICAC in promoting anti-corruption and integrity culture. The importance of a strong political will and non-interference approach to combating corruption seems to be obvious, but it is not difficult to observe that Many jurisdictions around the world have only adopted half-hearted measures to fight corruption, or even worse. Anti-corruption agencies there are crippled by legislative and executive means because of partisan considerations or illegitimate interests on part of the political elites. Secondly, the independence of the ICC in its operations. Our independence is guaranteed both constitutionally and statutorily. Article 57 of the Basic Law of the Hong Kong SAR stipulates that the ICAC shall function independently and be accountable to the chief executive. That is the head of the Hong Kong SAR government. Section 5, subsection 2 of the ICAC ordinance specifies that the commissioner of the ICAC shall not be subject to the direction or control of any person other than the chief executive. It is also laid down in the same ordinance that ICAC shall be funded from the general revenue of the government, thereby ensuring that necessary resources will be allocated to the Commission, and that we have the autonomy in appointing officers. The double layers of constitutional and legal safeguards provide the cornerstone on which the ICAC can operate independently without the fear that our powers, independence in discharging duties, and operational resources will be curtailed. Thirdly, the rule of law. There is a fundamental correlation between the rule of law and absence of corruption. They will reinforce each other and create a virtuous cycle. The rule of law enables an anti-corruption regime to function effectively, which in turn will further sustain the rule of law. This fundamental correlation is also summed up by the Rule of Law Index released by the World Justice Project. Under the index, the absence of corruption that I have mentioned is regarded as one of the major factors affecting the rule of law of a jurisdiction. One of the more prominent features of the strong rule of law in Hong Kong is the division of duties among the ICAC, the Department of Justice, and the judiciary in carrying out their respective mandates. While the ICAC conducts its investigation without any intervention, whether or not to prosecute an offender is vested with the Department of Justice, which exercises its decision professionally and independently. Every accused person is entitled to a fair trial before the independent judiciary. Fourthly, an integrated anti-corruption strategy. It has been recognized globally that anti-corruption efforts should be directed not only at detecting and punishing offenders, but also at correcting the social causes, such as people's misconception and tolerance that allow corruption to flourish, as well as improving systems and procedures to prevent corruption from happening. This comprehensive approach is aptly reflected in the United Nations Conventions Against Corruption, which came into force in 2005. It is also out of this groundbreaking understanding of the need of a comprehensive solution about 48 years ago that the ICAC has been taking a holistic and coordinated three-pronged strategy to tackle corruption since its establishment. Putting this strategy into practice, the law requires ICAC not only to investigate corruption, but also to examine practices and procedures in the public sector, assist the private sector in identifying vulnerabilities in their systems, and recommend solutions to close those gaps, as well as to raise public awareness and foster public support for preventing corruption. According to some academic research, Hong Kong's successful anti-corruption model has inspired over 40 different jurisdictions to set up independent anti-graft agencies and adopt comprehensive strategies similar to ours to fight corruption. These components serve to sustain the efficacy of Hong Kong's anti-corruption system. However, corruption is always elusive and ever-changing. It may exist in different forms and crossbreed with other illicit practices and crimes, making it difficult to identify, track down, and eradicate. Hong Kong and ICAC have been keeping in pace with the evolving anti-corruption developments in recent years, in particular the issues of bribery of foreign public officials, whistleblower protection, anti-money laundering, and transparency of beneficial ownership. Other stakeholders, local or international, have been rightfully active in calling out these issues and urging governments and competent authorities to address them. While these efforts are admirable and should be commended, the missions of these stakeholders are better served if they can ensure that their approaches, analysis, recommendations, and sometimes criticisms are objective, fair, fact-based, and with thorough understanding of a place anti-corruption efforts and measures. One of the examples of this advocacy is the Exporting Corruption Report issued by TI in October last year. The report assessed the progress of member countries of the Organization for Economic Cooperation and Development, OECD in short, on enforcing OECD Convention on combating bribery of foreign public officials in international business transactions. Hong Kong, though not a party to the convention, was included in the report by TI unilaterally. The report asserted that our city, among other issues, has limited or no enforcement against foreign bribery and the related money laundering. I would like to take this opportunity to clarify some of the misconceptions and refute the unfounded comments contained in the report. First, I would like to address the fundamental issue that it is indeed puzzling to put Hong Kong under the evaluation of enforcing OECD Anti-Bribery Convention. According to TI, Hong Kong is included in its evaluation simply because it is regarded as one of the major exporters in the global trade. In doing so, TI adopted a presumption that the prevalence of foreign bribery is roughly in proportion to export activities. Our view is that this presumption and the inclusion of Hong Kong in its evaluation are simply flaws, because there is no proven correlation between foreign bribery risk and the volume of exports. The report also did not give due regard to the specific nature of the export trade of Hong Kong. Even TI acknowledged in the report itself that the potential for foreign bribery could be affected by factors other than the level of world exports, such as foreign investment, a place culture, business ethics, corruption risk in specific industry sectors like public procurement and economies. This begs the question or the validity of the assumption. In the case of Hong Kong, the products exported from and imported to our city are mainly household electrical appliances and personal consumable goods like textiles, toys, and timepieces, etc., which constitute about 40% of the merchandise export volume. Our exports of services are mostly, about 60%, travel and transport related. It is hard to see how these kinds of export can substantiate the assertion that Hong Kong has a high risk in exporting corruption. Hong Kong is also a renowned entrepôt in which the re-export of goods accounts for more than 80% of our exports. If we discount the volume of re-exports, Hong Kong's annual domestic exports in proportion to the world exports were in fact less than 0.5% for the period from 2016 to 2019. The share itself is much lower than the 2% benchmark adopted in TI's report. Putting these all together will give us a picture that it is groundless to simply link trade volume with foreign bribery risk without any empirical analysis of the characteristics of Hong Kong's exports and re-exports and its impact on the potential foreign bribery risk. The report also commented that Hong Kong does not have a specific law to tackle bribery or foreign public officials. Even though Hong Kong is not a signatory to the OECD Anti-Bribery Convention, and no specific foreign bribery law has been enacted here, this has not weakened our commitment to combat bribery of foreign public officials under our robust and time-tested anti-corruption regime. The ICAC has all along adopted a holistic approach to fight corruption on different fronts, including vigorous enforcement of anti-corruption laws, close international cooperation on law enforcement and corruption prevention, assist the private sector to enhance their corruption prevention capability and good governance, and collaborate with our counterparts in other jurisdictions to enhance their capacity to combat corruption. From the legal perspective, the bribery of foreign officials, which falls under the definition of agent under the Prevention of Bribery Ordinance, POBO in short, is criminalized under Section 9 of that law. It was ruled by the Court of Hong Kong that when an advantage is offered in Hong Kong, Section 9 of the POBO does apply, even if the offeree is a public official of a place outside Hong Kong, and the act or forbearance concerned is in relation to his public duties in that place outside Hong Kong. In that case, ICAC can invoke the powers under the POBO to take enforcement actions, including freezing the property which may be the proceeds of the suspected corruption. The Exporting Corruption Report has also stated that Hong Kong lacks legislation on whistleblower protection. Although at present there is no specific whistleblower protection law in Hong Kong, there is in fact a robust witness protection regime, including a number of legislative provisions which serve to protect witnesses of corruption and other crimes. Section 30 of the POBO makes the disclosure of details of an investigation a criminal offense, while Section 30A of the POBO prohibits disclosure of the identity of informers. The Witness Protection Ordinance, WPO in short, provides for the establishment of programs for the protection of witnesses and persons associated with them. The ICAC has a dedicated witness protection unit to provide protection measures for witnesses in corruption investigation, if deemed necessary. Experts and victims are protected in the same manner as witnesses, their relatives and close associates under the WPO. They are further protected under the Victims of Crime Charter and Section 26 of the Organized and Serious Crimes Ordinance, OSCO in short. Section 79B of the Criminal Procedure Ordinance, CPO in short, provides that witnesses who fear for their own or their family's safety may testify remotely via live video link. And the courts also possess inherent jurisdiction in common law to make orders to protect witnesses in appropriate situations, such as testifying behind screens and limiting the disclosure of their identity. Under Sections 122 and 123 of the CPO, the courts may order that part of or all of the criminal proceedings be held in camera. In recent years, about 70% of the corruption complaints made to the ICAC are on non-anonymous basis. This reflects the fact that members of the Hong Kong public have no concerns about coming forth to us for reporting corruption. The ICAC has all along been acutely aware of the high public expectations on the integrity and conduct of its officers, in particular in the handling of confidential information relating to complainants and investigations. Internally, a strict policy is in place to require all officers to observe the need-to-know principle. That is, all confidential information is only made available to officers who need it for discharging their duties. Besides, there is a well-defined system in respect of the declaration and avoidance of conflict of interests when conducting investigations. Officers must refrain from taking part in the deliberation, decision-making, investigation, or enforcement process in any matter in which he has a private interest. These mutually complementary measures ensure that all the confidential information is only released and used when it is absolutely necessary and appropriate. I would like to emphasize that Section 30 of the POBO prohibits the unauthorized disclosure of information regarding ICAC investigations. It governs not only members of the public, but also ICAC officers. Together with the legal requirement and the court orders, the composite measures in Hong Kong are not inferior to whistleblower protection law. It has also been commented in TI's report that money laundering continues to be a high risk of Hong Kong. This assertion is without basis. In fact, in September 2019, the Financial Action Task Force, FATF in short, an international government body that sets international standards on combating money laundering and preventing terrorist financing, published mutual evaluation report to assess the compliance and effectiveness of Hong Kong's anti-money laundering and counter-terrorist financing regime. That report confirmed that Hong Kong has a strong legal foundation and effective system for combating money laundering and terrorist financing, particularly in the areas of risk identification, law enforcement, asset recovery, counter-terrorist financing, and international cooperation. Hong Kong was the first jurisdiction in the Asia-Pacific region to have achieved an overall compliant result in that round of FATF evaluation. Since joining the task force in 1991, Hong Kong has been fully committed to carrying out the international obligations on anti-money laundering and counter-terrorist financing, and has been playing an active role in the FATF. On the part of the ICAC, during the mutual evaluation in 2018-19, being one of the key stakeholders, we have provided inputs in assessing the ability and vulnerability of Hong Kong in combating money laundering and the money laundering threat in respect of the predicate offense of corruption. Combating corruption should not stop at investigation and prosecution. Instead, the recovery of corrupt proceeds is one of the must-dos in our anti-corruption work. In Hong Kong, we have robust law enforcement to prevent the economy from becoming the haven of money laundering. At about the time when the ICAC was set up in 1974, Section 14C of the POBO was introduced to prevent a suspect or an accused person from disposing of his or her assets or removing these assets from Hong Kong while the investigation is being carried out. In addition, criminalization of money laundering activities, restraint of assets, and confiscation of crime proceeds under the OSCO, which the ICAC can also deploy, has proved to be a powerful tool in cutting the vein of financial crimes, including corruption. In respect of ICAC's law enforcement capacity, we have in-house professional forensic accountants to assist our frontline officers in conducting complex financial investigations and illicit fund tracing exercise. Furthermore, the Proceeds of Crime section of the ICAC has a mandate and expertise to trace, freeze, and deprive criminals of their corrupt and illicit crime proceeds. For example, in January 2021, 12 million Hong Kong dollars was confiscated from 2 defendants convicted in the listed company acquisition case. And as of September 2021, assets valued at $1,053.5 million continue to remain restrained. On the operational level, by joining the Fraud and Money Laundering Intelligence Task Force last year, the ICAC maintains close cooperation with the Hong Kong Police Force, Hong Kong Monetary Authority, and the banking industry to enhance the detection, prevention, and disruption of serious fraud and money laundering activities. The access to beneficial ownership information has been receiving increasing international attention. TI's report recommends Hong Kong should keep a central and public register of beneficial ownership. I do not concur with the suggestion because in Hong Kong, there has been timely review of legislation to address the legal gap. The transparency of beneficial ownership does not always mean that such information has to be made public. To fulfill Hong Kong's international obligations under the FATF, the Companies Amendment Ordinance was enacted in March 2018. It requires companies incorporated in Hong Kong to maintain up-to-date information by way of keeping a significant controllers register. The register is made available for inspection by law enforcement agencies, including the ICAC. In relation to international standards, while FATF requires the maintenance of beneficial ownership information, it is not a requirement to keep a central or public register. As a matter of fact, Hong Kong is among the first batch of jurisdictions to have mandated the keeping of beneficial ownership registers by companies. I would also like to emphasize that Hong Kong has taken a balanced approach to ensure the availability of beneficial ownership information and access by law enforcement authorities on the one hand, and upholding the appropriate level of privacy protection on the other. According to the FATF Mutual Evaluation Report 2019, Hong Kong is largely compliant with its recommendation 24, that is, transparency and beneficial ownership of legal persons. Ladies and gentlemen, both local and cross-jurisdictional corruption is ever-changing and has taken up new dimensions, as illustrated by new developments, and I have just highlighted. Hong Kong has an effective anti-corruption regime in tackling these issues, but in order to stay ahead of the game, we have to be even more innovative in developing countermeasures, enhancing our capabilities and agility, and collaborating with our counterparts and other partners in the local and wider international and local communities. The ICAC is fully aware that constructive criticism can serve as drivers to improve or to rectify inadequacies. However, they must be well-founded. In order to stay abreast of the anti-corruption trends and compliance requirements worldwide, the ICAC will persevere to continue our mission to entrench a culture of integrity in the place where we live, and we will definitely overcome the challenges in the years to come. Thank you.
Thank you, Mr. Pei. Our last speaker, Mr. William Tam, SC, should also be well known to many of you. Certainly, we are well known to each other, being former colleagues. Mr. Tam joined the then Legal Department of Hong Kong, now the Department of Justice, in 1994 as a public prosecutor. He has been in charge of a number of key positions in DOJ, including the Commercial Crime Subdivision, which advises the ICAC, the Commercial Crimes Bureau of the Police, the Securities and Futures Commission, and other law enforcement agencies on criminal matters. Mr. Tam specializes in commercial fraud, corruption offenses, and appeal matters. He was promoted to Deputy Director of Public Prosecutions in 2012 and was appointed Senior Counsel in 2015. He is currently the Chief of Staff of the Prosecutions Division and Head of the Policy and Administration Subdivision. With such solid prosecutorial experience, Mr. Tam will examine, from a practitioner's perspective, the range of criminal offenses available to fighting corruption in Hong Kong, including the widely used common law offense of misconduct in public office. We will also deal with practical matters, including sentence, restraint of assets, and confiscation of crime proceeds. Let us now welcome Mr. Tam.
Secretary for Justice, distinguished guests, ladies and gentlemen, good afternoon. It is certainly my great honor and privilege to be asked to speak at this conference on the topic of combating corruption in the mainland and Hong Kong. As the ICAC Commissioner has alluded to in his presentation to you, in the 1960s and early 70s, corruption was rampant in Hong Kong, and it permeated in just about every aspect of life then. But now, Hong Kong is rated and recognized internationally as one of the least corrupt places in the world. Without being complacent about the present situation in Hong Kong, I propose to examine what are the requisite components or features of an anti-corruption regime that make it effective in fighting corruption. And I do so by examining and focusing on our legal framework with a view to advocating for such components or features to be maintained or enhanced. First, a requisite feature of an effective anti-corruption regime, in my view, is that it must give due recognition to the, quote, cancerous, unquote, nature of corruption and its deadly consequences. Our courts in Hong Kong have long recognized corruption as, quote, an evil practice which threatens the foundations of any civilized society, unquote. Corruption is regarded in the same breath as drug trafficking, both characterized as cancerous activities. In particular, commercial corruption in the private sector has been described by our courts as, quote, an insidious cancer, secretly gnawing at the vitals of commerce, unquote. Corrupt commissions are said to strike at the root of the necessary probity of our commercial institutions. An effective regime must therefore recognize the deadly and insidious nature of corruption. No condoning or complacency can be countenanced, because if corruption is not tackled seriously enough, it will spread like cancer and undermine Hong Kong's social stability and its success as an international financial center. With due regard, due recognition of the serious nature of corruption, the anti-corruption regime must have a broad range of offenses available to effectively tackle corruption that may present itself in a variety of situations. The flagship anti-corruption legislation in Hong Kong is the Prevention of Bribery Ordinance. It was promulgated in 1974 against the background of rampant corruption then prevailing. The ordinance was enacted with a broad range of offenses that are fit for purpose and with a view to eradicating corruption. The offenses created cover not only public sector corruption, but also that in the private sector. A number of bribery offenses were enacted to tackle corruption. They proscribe soliciting or accepting an advantage by public servants as inducement or reward for performance of their duties, or by agents in the private sector in relation to the affairs or business of their principals. And the offeror of such bribery is also guilty of an offense. As you can see from this PowerPoint, a number of bribery offenses were created to cover a variety of settings. We have bribery to a public servant under Section 4, bribery for giving assistance under Section 5, bribery for procuring tender withdrawal under Section 6, in relation to auctions under Section 7, bribery by persons having dealings with public bodies under Section 8, and bribery to an agent in the private sector under Section 9, etc. But the Prevention of Bribery Ordinance went further than simply provide for bribery offenses. Section 3 of the ordinance imposes a strict requirement on civil servants with a preventive element, so that conduct or practice which is short of actual bribery but conducive to corruption is also made an offense. Under Section 3, any civil servant who solicits or accepts any advantage without the general or special permission of the chief executive shall be guilty of an offense. It is a broad offense that was created and intended to serve the mischief of preventing civil servants from being put in a position of temptation of corruption by seeking or taking any advantage without permission. It is remarkable that for this offense, it is not necessary for the prosecution to strictly prove any corrupt purpose of the advantage. A civil servant who asks for or obtains an advantage without permission could attract criminal liability. This offense under Section 3 introduces a preventive element into our anti-corruption regime to ensure that conduct which could render a civil servant vulnerable to corruption is, quote, nip in the bud, unquote, whenever detected. Another remarkable feature of our statutory framework is the broad language used in the ordinance, including the wide definitions of advantage, of agent, and other terms used in the offences. As Mr. Justice Hartman, then of the Court of Appeal, commented in the case of Hoy Russell, quote, the language of the ordinance is broad, necessarily so, in order to bring within its parameters the almost limitless circumstances in which bribes may be offered, unquote. As a whole, therefore, these provisions in the Prevention of Bribery Ordinance establish an extensive statutory framework in Hong Kong to combat the evil of corruption in the form of bribery. However, an anti-corruption regime will be significantly handicapped if it can only prosecute corruption involving bribery or an advantage being offered or accepted by an offender. That is because bribery is only one particular manifestation of corruption. Indeed, as observed by the Court of Final Appeal in the case of Sham Kwok Sheh, quote, the receipt of a bribe or an advantage is not an essential ingredient of corruption in its broad and general sense. A deviation from fidelity in the discharge of a person's duty can amount to corruption, unquote. Therefore, an effective anti-corruption regime must be ready to prosecute corruption other than bribery. That is, corruption in the form of misuse or abuse of position or power by a public official. In the legal framework in Hong Kong, the prosecution is able to resort to the common law offense of misconduct in public office to prosecute public officials for any abuse of their functions and positions. In the leading case of Sham Kwok Sheh, the Court of Final Appeal definitively held that the common law offense does not lack legal certainty, and the court identified the elements of the offense in express terms. In Sin Kam Hua, taking into account the recent English authorities on willfulness and recklessness, the Court of Final Appeal reformulated the elements which can be seen in this PowerPoint. It is important to note the court's guidance that, quote, the misconduct must be deliberate rather than accidental, in the sense that the official either knew that his conduct was unlawful or willfully disregard the risk that his conduct was unlawful. Willful misconduct, which is without reasonable excuse or justification, is culpable, unquote. It is remarkable to note that these landmark Court of Final Appeal decisions in Sham Kwok Sheh and Sin Kam Hua have actually been cited in other jurisdictions, thereby contributing to the development of this common law offense outside Hong Kong. And there have also, by now, been a series of appellate decisions in Hong Kong in which the elements and scope of this common law offense were further elaborated upon and clarified. For instance, in Xin Kam Hua, the Court of Final Appeal explained that even when the relevant conduct was not carried out in the performance of the officer's duties, it could still have such a relation with his public office so as to bring the office into disrepute, thereby supporting a conviction of the offense. In Wong Lin K, the Court of Final Appeal explained the matters to be taken into account in determining whether a person occupies a public office, quote, entrusting him with powers and discretions to be exercised for the public benefit, unquote. And the Court of Final Appeal helpfully identified the essence of the offense. Quote, there is in reality only one question. Did the conduct with which the accused is charged consist of an abuse of a power, duty, or responsibility entrusted with him or her and exercisable for the public good, unquote. And in the case of Wong Kwang Shun Po, the Court of Appeal gave useful guidance on what amounts to serious misconduct. Quote, any public officer in the execution of his public duties must not only be impartial and avoid doing anything in conflict with his personal interests, but must also ensure that his conduct will not lead to any reasonable criticism, cause any suspicion, or bring his office into disrepute. In performing his public duties, a public officer must never harbor any selfish motive and must not intentionally benefit himself or his friends or relatives in any way, for instance, by providing any assistance to them so that they would enjoy an unfair advantage. Any conduct of a public officer which contravenes the above principles is serious misconduct, unquote. And in the case of So Ping Chi, the Court of Appeal gave guidance that in cases of misconduct involving nonfeasance of duty, the misconduct will only be culpable if it was serious and willful. Willful being in the sense that the non-performance was both voluntary and deliberate. Apart from guidance from the courts on the elements and scope of the offense, we have also seen the common law offense being developed, applied, and upheld by the appellate courts in a variety of situations. And that development has significantly strengthened our regime in its combat against corruption. As can be seen from this PowerPoint, we have seen cases upholding the convictions of different types of misconduct in a variety of settings. The offense of MIPO can cover an offender benefiting oneself without disclosing conflict of interest, benefiting friends without disclosing conflict of interest, willfully disclosing confidential information to assist commission of crimes, abstracting and misusing official data for his private use, revealing police identity to procure sexual service from a prostitute, etc. And in the more recent and high-profile case of Hui Raphael Jr., the common law offense was applied to misconduct of a senior official by way of an ongoing inclination to favor an outside party as a result of a pre-office payment, which would, quote, impair his capacity to exercise a disinterested judgment, unquote, or, quote, more colorfully would fasten upon himself golden fetters which preclude his freedom of action, unquote. What is important, as demonstrated by these cases, is that a successful prosecution of the offense of misconduct in public office does not depend on proof of any advantage being offered to or accepted by a public official. A serious and deliberate abuse of a power or duty by a public official, especially in a conflict of interest situation, suffices for the purpose of the common law offense. This offense gives the prosecution a very effective choice of charge to prosecute corrupt abuse of power or duty, even in the absence of proof of an advantage. Further, these cases demonstrate that the courts in Hong Kong, the Court of Final Appeal in particular, continue to be at the forefront in developing the anti-corruption law such that it will remain vibrant and efficacious in order to tackle the mischiefs of corruption. With such development in the case law, Hong Kong is able to maintain and enjoy an effective set of offenses, common law and statutory, in the combat against corruption. Apart from having available a broad range of offenses to prosecute corruption, the anti-corruption regime must be ready to impose sentences that have deterrent effect. As can be seen from this PowerPoint, the Court of Appeal in Lai Yuk Koi stated that the imposition of deterrent sentences is an important factor in the community's efforts to eradicate corruption, unquote. It must be clearly made known to those who are tempted to commit corruption offenses that if discovered and convicted, they will be subjected to a sentence of a substantial character. In Hong Kong, immediate custodial sentence is the norm, except in very rare cases, even for a first offender. And generally speaking, the courts here make no distinction between the culpability of public sector corruption and that of private sector corruption. Both types of corruption call for a deterrent sentence. As stated by the Court of Appeal in Quan Chi Chong, quote, a punishment that fails to deter will produce all the wrong signals, just as sentences which act as a deterrent will reinforce this community's efforts to rid itself of corruption, unquote. Recognizing the serious nature of corruption, the courts in Hong Kong do adopt a robust attitude in sentencing corruption offenses to achieve deterrence. In addition to any sentence imposed, a corrupt offender must also not be permitted to keep his ill-gotten gains. To deter corruption, in addition to sentencing, an effective regime must have a mechanism for the disgorgement of such gains. In Hong Kong, under Section 12 of the Prevention of Bribery Ordinance, there is a mandatory obligation on the sentencing court to order a corrupt offender to make restitution of any bribe or advantage received by him. Restitution is to be made to such person, public body, or the government in such manner as the court directs. The prosecution may also rely on the restraint and confiscation regime in respect of proceeds of crime under the Organized and Serious Crimes Ordinance to apply for the confiscation of the bribes. I should also point out that in Hong Kong, any person who knowingly or having reasonable grounds deals with the proceeds of corruption can be prosecuted for money laundering under the Organized and Serious Crime Ordinance. Therefore, in our legal regime, not only are the corrupt offenders caught and prosecuted, so are those who assist in the disposal of the proceeds of corruption. Collectively, these mechanisms serve to underline the gravity of corruption and enhance deterrence. Last but not least, I must emphasize an indispensable feature of an effective regime to combat corruption. There must be guarantees of independence given to the institutions which are entrusted with powers and functions to act and administer justice in our criminal justice system. In the context of Hong Kong, we have such guarantees of independence which are backed by the solid rule of law foundation under the Basic Law. The Basic Law being the constitutional document of the Hong Kong Special Administrative Region. Our investigative agency, the ICAC, is dedicated to and specialized in investigating corruption offenses. It is imperative that it must be able to function independently and carries out its investigations without being subject to any undue pressure, political or otherwise. The independence of the ICAC is enshrined under Article 57 of the Basic Law. It is an agency that is truly independent, separate from other government bodies, and it is accountable only to the Chief Executive. The prosecution service must also be able to act independently. Prosecutors must be able to make prosecutorial decisions fairly and impartially and strictly according to the law and the evidence. Under Article 63 of the Basic Law, prosecutors in the Hong Kong Special Administrative Region are guaranteed this prosecutorial independence so that their decisions are made, quote, free from any interference, unquote. Under our prosecution code, in making decisions and exercising discretion, a prosecutor must not be influenced by the social or political affiliation or the official or other position of the suspect in the community. Our judges also enjoy judicial independence, as evident from the framework that has been laid down in the Basic Law, including the security of tenure and the immunity of judges. All of our judges are required to administer justice, quote, without fear or favor, unquote, as per their judicial oath. These are not just empty words, but are real assurances of independence that are given to the ICAC, the prosecution, and the judiciary, and they form part of our solid rule of law foundation. These guarantees of independence are critical to the effectiveness of our anti-corruption regime, and they must be and must continue to be steadfastly protected and vigilantly upheld. Ladies and gentlemen, thank you.
Thank you, Mr. Tam. Looking at the time, it seems that we don't have the luxury of further reflection by our distinguished speakers, but I'm sure there's already enough in their speeches for you, everyone here, to take away, to reflect upon and digest. And I would like to round up this session by thanking our distinguished speakers, Mr. Xi in Beijing, Mr. Pei, Mr. Tam, for their illuminating and well-prepared speeches. I would also like to thank all of you for being here, taking part in this session. And thank you very much.
Thank you so much. Thank you, Mr. Robert Lee, and also our speakers, Mr. Xi Weizhong, Mr. Simon Pei, SBS IDSM, and also Mr. William Tam SC. Thank you so much for an insightful discussion on examining the requisite components of a robust anti-corruption regime and considering whether the existing laws and regulations in Hong Kong are effective in combating corruption. So now we have 10 minutes break. I will see you again after 10 minutes. Thank you. Hello, ladies and gentlemen. Our fourth panel session will be start very soon. May I invite you all, please be seated. Thank you. Hello, everyone. Welcome back. For the fourth panel session on crowdfunding or crime funding, the last session of conference today, we're pleased to have Mr. Stephen Hong with us. Mr. Hong is the past president of the Law Society. He served as a member on the Communications Authority, the Law Reform Commission, the Professional Services Advancement Support Scheme Vetting Committee, and Financial Reporting Council. So, Mr. Hong, the stage is yours.
Good afternoon, ladies and gentlemen. When I accepted the invitation to be a moderator this afternoon, I had no idea what crowdfunding was. With the help of William, sent me some link. I looked it up, and now I can tell you. I'll do it by way of introduction. Now, crowdfunding typically refers to the use of small amount of money obtained from a large number of individuals or organizations to fund a project, business, personal loan, other needs through online web-based platform. There are four types of crowdfunding, and they are peer-to-peer lending, equity crowdfunding, reward-pre-sale crowdfunding, and donation funding. Now, a typical feature is that these members of the public have not met and do not know the genuine identities of these developers or their companies. Their decision to contribute is based essentially on information and representation made by the developers at the online platforms. Most often, there's no channel for them to verify the representation made due to lack of sufficient information or knowledge of the product or business plan involved. In light of the rapid growth of the crowdfunding activity, both in Hong Kong and across the globe, this session would like to explore the following issues. First of all, the current legal framework in Hong Kong. In short, we do not have specific ordinance regulating crowdfunding, so to speak. What is not regulated at all are non-investment related crowdfunding activities, such as rewards or pre-sale crowdfunding and donation crowdfunding. He also identified some risks and problems of crowdfundings. And according to the Notice of Potential Regulations applicable to and risks of crowdfunding activities issued by the Securities and Futures Commission in May 2014, 6 risks were identified. The risk of conducting general solicitation and license activities, risk of platform failure or insolvency, platform operates outside Hong Kong, information asymmetry and lack of transparency, cybersecurity, and illegal activities. This afternoon, the speakers will also share with you some experience from overseas jurisdictions. Now, in short, in the UK, excuse me, the Financial Conduct Authority regulates equity and loan-based crowdfunding. Donation-based, prepayment, or reward-based crowdfunding platforms do not require the FCA's authorization. Now, in the States, under the Securities Act, the crowdfunding platform is required to undertake a background check on each issuer, relying on the exemption to reduce the risk of fraud. Now, in Canada, Canadian crowdfunding market is regulated by the National Crowdfunding Association. In Canada, the equity-based crowdfunding is the only type that is regulated. In Australia and New Zealand, both jurisdictions treat the operation of equity-based crowdfunding platform operators as a financial service provider and are subject to the licensing regime. Platform operator must comply with a number of ongoing obligations since the determination made by the relevant regulator at the licensing stage. Now, this afternoon, we have 3 speakers that will share their experience or their view on crowdfunding with the audience. May I first introduce Mr. Jonathan Kaplan, QC. Jonathan is a Queen's Counsel practicing in London, but who has appeared many times in the courts of Hong Kong, Singapore, and Brunei. He also advises in the Gulf and in Europe. His clients include government agency, corporations around the world, and individuals. He is regularly listed in the top tier of the Queen's Counsel in the legal directories. His principal areas of work include criminal and civil fraud, regulatory issues, corporate liability, media law, and public inquiries. He has most recently appeared in Hong Kong in several cases in the Court of Final Appeal concerning the construction of money laundering provisions. Jonathan is a bencher of Gray's Inn, a recorder of the Crown Court, an arbitrator, and a judicator for the Broadcasting and Publishing Standards Tribunal in Dubai. The next speaker will be Mr. Joseph Jie, SC. Joseph was called to the Hong Kong Bar in 1984 and commenced his practice in 1985. He was appointed as senior counsel in 2006. Mr. Jie practices in criminal law with expertise and interest in white-collar crimes. He has been involved in many high-profile cases in Hong Kong and has acted for either the prosecution or the defense. He is a member of the Devote Chambers, being the only silk with exclusive criminal practice in that chamber. Now, Joseph has been the senior vice chairman of the Hong Kong Bar Association, chairman of the Duty Lawyer Service Council, and is currently the vice chair of the Society for Rehabilitation and Crime Prevention. I'm sorry. I will forfeit my cell phone. And the third speaker is Mr. Anthony Chow, currently serves as the Acting Deputy Director of Public Prosecutions of the Prosecution Division of the Department of Justice. He has advised on and prosecuted money laundering, commercial fraud, and public order offenses, and conducted criminal appeals at all levels of court. He is also a member of the Hong Kong Institute of Certified Public Accountants, and he is a qualified assessor of the Financial Action Task Force and the Asia Pacific Group on Money Laundering, which are both global independent intergovernmental organizations committed to implement international standards against money laundering and terrorist financing. Without further ado, I will invite Joseph Jie, SC, to deliver his first presentation. Thank you.
Thank you, Stephen. Good afternoon. Welcome back, Director, fellow speakers, honorable guests. Now, this is the fourth topic of today's session in the criminal sector. This topic, as the name tells you, is about the improper use of crowdfunding as a form of crime funding. We have already heard from the moderator a very brief outline of the kinds of crowdfundings that there are in the world, not only in Hong Kong. There are 4 types, and he's already told you what they are. Now, because my speech now concerns topic 1, which is what the current legal framework in Hong Kong is over crowdfunding, and therefore I will limit myself only to that very small area. As the moderator, Stephen, has said, it equally applies to me, and I'm sure to the other speakers. Before we were invited to do a speech in this topic on crowdfunding, nobody actually knows what it is. We learn as we grow, and through the support of the Department of Justice, through the research materials they had supplied me and my own research, this is the end product. And I'm going to update you on the current legal framework in Hong Kong on crowdfunding. Now, as the moderator has already said to you, there is actually no particular piece of legislation in Hong Kong that directly regulates crowdfunding activities in Hong Kong. However, we do have a variety of pieces of legislation here and there, which may be relevant to crowdfunding activities. Insofar as statutes are concerned, I think we can safely divide them into 2 categories. Now, the first categories are 3 pieces of ordinance which have provisions which directly regulate very specific aspects of certain types of activities which can be regarded as crowdfunding activities. Now, these 3 ordinances are the Companies Winding Up and Miscellaneous Provisions Ordinance, Chapter 32, Laws of Hong Kong, the Securities and Future Ordinance, Chapter 571, and the third one is the Moneylenders Ordinance. I'll go into those a little bit later. The second category of legislations which are relevant to crowdfunding activities are the general pieces of legislations that are of broad applications to our everyday lives and activities anyway, and I'm sure you are well familiarized with those, but there are many of these. Now, these are the ordinances which, in my view, may be relevant to controlling crowdfunding activities, and these are various offenses under the Theft Ordinance, Chapter 210, the statutory conspiracy, which is created by the Criminal Procedure Ordinance, Chapter 221, the offense of trade misdescription under the Trade Description Ordinance, Chapter 362, the Summary Offences Ordinance, Chapter 228. I mean, it's hard to imagine that Summary Offence Ordinance is actually relevant to crowdfunding, but I'll explain to you later. And also, and most important of all, is the offense of money laundering under the Organized and Serious Crimes Ordinance, Chapter 455. Now, there's another piece of legislation called the Anti-Money Laundering and Counter-Terrorist Financing Ordinance, which lends support to the offense of money laundering, but I do not think it has any direct relevance to regulating crowdfunding activities as such. So I will just mention it in passing, but I won't go into it. Now, this second type of statutory provisions, or second category of statutory provisions, are relevant to all four types of crowdfunding activities. Whereas the first category, those three pieces of legislation I mentioned earlier, those are only relevant to two of the four types of crowdfunding activities, namely the equity crowdfunding and the peer-to-peer crowdfunding. And there you are. So you see how complicated the situation is. So we have different sorts of crowdfunding activities, and then we have different pieces of legislations here and there. Some only relevant to certain types of crowdfunding activities, and others more relevant to all types of crowdfunding activities, but not directly, only indirectly. And then we also have the common law, apart from these statutory provisions. Under the common law, we have, as you know, the offense of champerty, which is an offense which governs a certain type of crowdfunding activity. We have the common law offense of conspiracy to defraud. We also have offenses like aiding and abetting, counseling, procuring, and abetting. And lastly, we have a joint enterprise. So all those will be relevant. Now, for my part, despite there's a lack of a single piece of legislation which targets crowdfunding activities as such, I do not have any particular critical comments about this particular state of affairs. Do we really need a comprehensive piece of legislation to govern crowdfunding activities? It depends. It depends. Because after all, crowdfunding activities originated from an honorable cause. You know, what the idea behind crowdfunding was initially to enable the much less prominent young entrepreneur who may have an idea, who may have a vision, to be able to raise enough capital in order to fund his project. He doesn't have any particular bankers or institution as his backers, but he needs the money. He doesn't need a lot. He needs a small amount. And so this idea of crowdfunding appeared. Crowdfunding is really only about raising money from the public, nowadays online, by advertising that they have a particular idea, a particular objective. They have some tasks, maybe an investment that they want people who may be interested to put money in to support it. And because we have a lack of direct regulatory legislation, really, there are risks. But the idea behind crowdfunding has always been noble. Crowdfunding can actually also support charity. I mean, it's been used a lot in charity. So don't look at crowdfunding as necessarily, being an activity which crime funding. Crime funding happens. But the origin of crowdfunding, let's not forget, it came from laudable and honorable causes. Now, the problem with crowdfunding only arises when, through time, it became abused, distorted, and manipulated in different ways. But let's not be surprised, because even if you have schemes that are highly regulated, you still encounter people, operators, who are dishonest, who make use of loopholes anyway. So these things happen not because it is unregulated. They happen even in regulated areas. However, I do agree that where you do not have a specific piece of legislation which directly controls crowdfunding, then it becomes more tempted and it becomes easier for those who are minded to misuse crowdfunding for the purpose of crime funding. Now, the need for legislation to regulate crowdfunding has been recognized overseas. As you've heard from the moderator, there are certain countries which have direct pieces of legislations. So it is a trend in the world to introduce statutes to directly regulate crowdfunding. But in my view, whether Hong Kong should go down that road, it's not about whether Hong Kong should look to appear to become trendy or to appear not to be left behind by the world. I think it really depends on whether there's a need, whether it is practicable, whether the circumstances are there now, whether now's the right time. We may have crossed the, reached the crossroad to think about this problem. I think that at the moment, perhaps we are near there. Not yet there, but we are near there. And I'll explain in a moment why I think that we are near there, but we are not yet there. Now, as the focus of my topic is about the laws in Hong Kong, which are relevant to crowdfunding, I'll return to that now. I'll deal with those three pieces of legislations in the first category, which do provide some sort of regulation over direct crowdfunding activities. The first, as I've said, is the Companies Winding Up and Miscellaneous Provisions Ordinance, Chapter 32. Now, after I have provided you with a summary of what that ordinance is doing, you will understand what I've been saying. This is just a piecemeal provision. Now, under this ordinance, it restricts the offer of shares or debentures to the public through the publication of a prospectus in which the shares or debentures of a company is offered to the public for purchase or subscription. So that's what it does. So if there is any such offer in a prospectus of shares or debentures to the public, then it may be a form of crowdfunding, and therefore, the provision in this ordinance is relevant. Under this ordinance, it imposes very strict requirements on what can be printed in the prospectus. Breach of that requirement will lead to civil liabilities. Civil. So if there's a prospectus that failed to meet the requirements that have been set according to the ordinance, it doesn't result in a crime. It's only civil. Compensation can be ordered to be paid. Okay, it's another thing for the prospectus to contain untruthful statements. Then it's a crime. Okay, so that disposes of that ordinance. Let's forget about that ordinance. And then the next one is the Securities and Future Ordinance, Chapter 571. Under this ordinance, it prohibits certain regulatory activities in connection with an investment advertisement or the carrying on of certain regulated activity without a license. In the event of a breach, there are criminal sanctions. And again, as with the previous ordinance, this ordinance only affects a very, very limited aspect of equity crowd funding involving the use of a prospectus. And lastly is the Moneylenders Ordinance, Chapter 163. Now, if the crowdfunding platform is being utilized to have contributors. Contributors means the people who are the donors, the public. They are contributing the funds to the platform. These are the contributors. Now, if the platform is being utilized to have the contributors to act as lenders, namely, they are using the platform to want to lend money to the public, to other people who are interested, who want to borrow money, and they want to meet each other on the platform. This is what is known as the peer-to-peer crowdfunding. One of the 4 types of crowdfunding. So in that scenario, this sort of platform may fall foul of the Moneylenders Ordinance because for a moneylender to be operated as a business, there has to be a license. And very often, actually, invariably, this kind of peer-to-peer crowdfunding platform would not have a license. So that's a way for them to bypass the requirement of the Moneylenders Ordinance. And in the Moneylenders Ordinance, the ordinance actually imposes very strict, stringent capital requirements in order for an institution or somebody to become a licensed moneylender. That's why you have this regime of license. But in the peer-to-peer platform, anybody can become a lender. So that's the risk that this type of crowdfunding activities will have for the borrowers. The borrowers won't have any security. They're simply borrowing money online from somebody that they do not know, they don't have enough information about. So the Moneylenders Ordinance therefore only regulates that aspect of crowdfunding. Now we go to the second category of statutes. And I'll begin with the theft ordinance. Now, under this piece of legislation, there are many offenses which may be relevant to crowdfunding activities. Now, let me give you a scenario. Because crowdfunding platforms are unregulated, you may have some unscrupulous operators who decide to make use of the platform to raise money, but actually, the real object is for another purpose. In other words, they are deceiving the public. So it's a fraud. It's a deception. But the public, once they have donated the money to the platform, they may not know. They believe that the money will be used for one particular purpose, when in fact, It's been used elsewhere, or in fact, it hasn't been used for anything. It's just perhaps placed in a bank account for personal use by the people behind the platform. So the platform can be an opportunity for the fraudsters to be deceiving the public. So where that happens, we have the offenses of theft, obtaining property by deception, the handling of stolen property, and fraud. They can all be applied to that sort of situation only after the crime has been committed and only after the culprit has been caught. So that is only after the event, which may be too late. So it's not preventive. Anyway, and also, of course, if there are more than one people involved in this conspiracies. So it's only in this scenario that the prosecutor will have a whole selection of offenses with which to punish the culprit. And I'm sure by that time, all the money will have been dissipated. And of course, there are also statutes, provisions which enable the police and the law enforcement agency to freeze the bank accounts, to seize the funds. However, even where it's fortunate that the money is still not yet dissipated and is discovered and seized and frozen, the difficulty will arise of whether it is possible to actually refund this money to the contributors, to the victims, to the people, to the donors, to the public who took part in this platform, unless there is a detailed register kept by the platform. But there is no law requiring them to keep such a register. If the people who are donors, they donated the money and they believe that they have parted the money for a particular purpose, they never had the intention of getting the money back. So they may not want to leave any particulars, any home address, telephone number, or even the names. So there may be difficulty, even in the case of a bust, to be able to find these victims and make restitution. More likely than not, it won't happen, and the money will get confiscated. So crowdfunding can be risky. Of course, I'm talking about donation crowdfunding here. I'm not talking about equity where people are investing. I'm not talking about peer-to-peer crowdfunding where the people are making loans to the public. And here I'm talking about donation crowdfunding, one of the 4 types, where the public donates to a particular platform for a particular advertised object. Now, the next piece of legislation is the Criminal Procedure Ordinance, Chapter 221. I'll be very quick on this because the only thing it adds is the conspiracy. So when the police, for example, when the prosecution has picked a statutory offense like theft, handling stolen property, or obtaining property by deception, and you want to put that in the context of a statutory conspiracy, then you make use of the statutory conspiracy. But where is fraud? And of course, as you know, it becomes a common law offense of conspiracy to defraud, the only common law conspiracy in Hong Kong. Now, Trade Description Ordinance, Chapter 362, will tell you why it is that this kind of online crowdfunding activities is even more risky than you think. Because for the first 2 pieces of legislation, I've been using examples where crimes have been committed, where the platform has been used to deceive people, frauds, and the money was stolen. But under the trade description ordinance, it doesn't even have to go that far, because as soon as an object which had been advertised on the platform had been used to have donors donate to the platform, and then it turns out, there's something wrong with the description of that object. It wasn't exactly what I had thought the object was. There's a misdescription somewhere. It's a crime. It's a trade misdescription. That's the offense. However, the really scary part is this. For an operator or the platform, the platform, for the platform operator to be prosecuted for trade misdescription, he doesn't need to be proved to have culpable mind, because trade misdescription is an offense of strict liability. It means that even if the operator were innocent, he didn't want to commit an offense, he wasn't being dishonest, but it just something went wrong, when he was putting the money to use in somewhere, it didn't fit what he had been advertising the money would be put to. Something went wrong, something innocent, some mistake was made somewhere. And what happens if one of the many donors discovered this and he lodged a complaint? And he complained against the platform. And the platform gets raided. And then it is suspended. And the bank account is frozen. What if there is an investigation? The entire platform will be put on hold. The entire operation will cease. The money will not be used as advertised. The scheme will just fall apart because of one person's complaint. Now, under the ordinance, for the operator to be prosecuted for trade misdescription, he has his statutory defenses, and I'll tell you what they are. He can argue, he can prove that the trade misdescription arose due to a mistake or due to an accident, and that he had taken reasonable precautions. So those were his defenses. In other words, because the burden is on him, of course, because these are defenses, if the operator fails to prove his statutory defenses, he gets convicted. The scheme becomes, quote, well, illegal in that sense. And on the other hand, if he succeeds in proving his defenses, that these trade misdescriptions arose because of a mistake or because of an accident, and he had taken reasonable precautions, he gets off, he is acquitted. But the scheme would have been put on hold for a long time, pending the investigation and pending the legal advice and pending the prosecution and the trial. The donor still suffers. So this can happen to any of the donation crowdfunding platform. This can happen even for a donation crowdfunding for charity, not necessarily for an illegal purpose. So that's the kind of risk the public is running. So next time when you want to do a donation on crowdfunding, think carefully. Okay, maybe it's a small amount of money, maybe you don't want it back, but think about the risks before you make a donation. Now, the Summary Offense Ordinance, Chapter 228, specifies that it is a criminal offense to organize or participate in any form of donation, collection activity in public without a permit from the Director of Social Welfare or the Secretary for Home Affairs. So in Hong Kong, if you want to carry out any form of donation activity in public, you need to have a permit. That's what it says. Otherwise, it's a summary offense. Now, the gray area in this is that in the definition of what is a public, what is meant by public, because the ordinance is quite archaic. It hasn't followed the technological development in time, so we really do not know whether public includes an online platform. It may not. There's no case on the point. So there you are. I mean, unless it is clear what public means, there is a risk. Of course, I mean, if you're walking on the street on a Saturday morning, you see some young students, selling tickets. You can assume that they have a license, but otherwise, if you see people coming up to you with a box and asking for donations, now you don't know whether they have a license or not. It may be for a charitable cause, but if there's no license, and you should ask for a license to see the license before you actually make a donation. I would like to move on to the common law first before I go into money laundering, which is the highlight. Now, what is the common law offense of champerty? I'm sure you've heard of some cases in Hong Kong where people have been prosecuted for champerty, but it's rare. Champerty is committed where the fundraiser have people contribute towards supporting the costs of a particular civil litigation in return for them having a share in the winnings from that litigation, should that litigation be victorious. In other words, if people are betting on the outcome of a civil case, hoping that if they place their bets on the right side, which eventually wins, and there are winnings in return, he'll get a share. It's just like lottery, it's just like gambling. But the dignity of the judicial process is being misused, just like a casino. It's illegal. Remember, it's a criminal offense. If people ask you to, put money in, there's this case, it's reported in the newspaper. You want to win the case, you raise your stake, you put in more money, we have more money, we get 2 senior counsels instead of 1. You have a higher chance of winning. The other side only has a junior counsel, that sort of thing. Yeah, well, that's an offense. That is also crowdfunding, but it's a criminal offense. Which leads me directly to the centerpiece of this speech, crime funding. How can crowdfunding become crime funding? What are the relationships between the two? I'll begin by identifying the piece of legislation which may be relevant to this. This is the Organized and the Serious Crimes Ordinance, Chapter 455, because it is under this ordinance that the offense of money laundering is created. Now, money laundering as an offense has become very prevalent in recent years. There have been many qualifying appeal decisions explaining the meaning of the offense of money laundering. And also, of course, anti-money laundering is a global trend. You know, all the countries, they have put their heads together to try to curb this kind of activity. Because money laundering can take many forms. And here, I'm only talking about how crowdfunding can become money laundering. You know, I'm not here concerned with other forms of money laundering. Money laundering has its purpose to tackle some very serious problems involving unregulated cross-border fund movements, and actually, worst of all, money laundering arises mainly from the fact that more likely than not, other very serious criminal offenses have been committed, and therefore there is money laundering. So where the law enforcement agency may not be able to identify and prove those offenses, they can tackle the crime through regulating the flow of money or the funds that have been derived from those crimes. Originally, the notion of money laundering and crowdfunding had no connections with each other. They had separate developments. I mean, crowdfunding was an even more recent invention than money laundering, although money laundering is not that particularly old in itself. So in Hong Kong, what is money laundering? Now, we have a pretty good summary of it in the section 25, subsection 1 of the Organized and Serious Crimes Ordinance, chapter 455. In a nutshell, money laundering is committed by somebody where that person deals, namely handles, deals with, he does something, he performs an act. He deals with a property. The property usually is money, funds, proceeds, usually. When he deals with that property, he either knows, he has knowledge that the property represented proceeds of very serious criminal offense, or he has, at the time when he's dealing with that property, he has reasonable grounds to believe that property he's dealing with represents the proceeds of very serious criminal offense. So there are two ways of committing money laundering in Hong Kong. Either he knows or he has reasonable grounds to believe. And the difficulty often arises with the second type of money laundering, having the reasonable grounds to believe, because under our Hong Kong law, even if somebody doesn't know that he was dealing with proceeds of an indictable offense, he can still be guilty of money laundering. If objectively, he ought to know if there are reasonable grounds for him to know. So, money laundering can be an offense that is committed very easily. So next time, if somebody asks you, for example, to lend a bank account, for his use, and then you ask no questions, and you didn't care less, and then millions and billions of dollars of money went through that bank account, which were tainted money, you might be guilty of money laundering, even though you didn't know. Because you might be, they may say, oh, you have turned a blind eye. There is a willful disregard of what is obvious. Okay, so that is really a very brief summary of what money laundering is in Hong Kong. Now, so how does crowdfunding activity come into it? And I'm here only talking about the specific type of crowdfunding activity known as the donation crowdfunding. I'm not concerned with equity and the reward type or the peer-to-peer type. Those I've dealt with. Now, where the donation crowdfunding's objective is openly to raise money for an illegal purpose or to commit a crime, this will give rise to a crime funding scenario. The activity of raising that money for a legal purpose itself becomes an illegal activity. Now, it is not difficult to think of such real examples that have happened in Hong Kong. I can give you many examples, but I'm sure you will understand if I pick examples like public crowdfunding to support rioting, to support arson activity, to support pro-independence, or to support terrorist activities. I'm here only to tell you what the law is in that respect. So under the Hong Kong criminal law, the fundraisers activity in operating that sort of a platform will already be guilty of many different types of offenses like aid and abetting rioting, aid and abetting arson, aid and abetting terrorism, counsel and procuring, conspiracy, or joint enterprise to commit those sort of offenses. And the contributors, the donors themselves, should they know what was the purpose of that platform and they still donated money to that platform, they could equally be guilty under our criminal law of conspiracy and joint enterprise. It's not without criminal liability. So once the money had been raised in that way, if the operator or the fundraiser then stored the money in a bank account, he keeps it in the bank account, a lawfully opened bank account, he is still guilty of money laundering. Because by keeping that money in a bank account, he's dealing with that property. And when he keeps that money in a bank account, he knows that money was tainted because it had been raised by an illegal fundraising crowdfunding platform. That already he's guilty of money laundering. If he further deals with it, for example, if he withdraws the money from that account to buy equipment, to then support to other rioting, arsonist activities, that is a further act of money laundering. Because that would be another form of dealing, is actually using the proceeds. So this is where these two notions have converged. I hope my speech today has been able to clear up some ambiguity or misunderstanding people may have as to the lawfulness of such a platform in which perhaps ordinary citizens on the street, they are asked to donate money towards a certain cause they think may be something that is in alliance with what they themselves believe, but it may be money laundering. It may be criminal. I believe that those platforms, if they had ever existed in the past, they are more likely to have disappeared by now. And that is why I said at the beginning of my speech, we may have been near that time when we should consider legislation to regulate crowdfunding activities, but maybe we are not yet there. Is there an urgent need for legislation? I believe that there are so many other old sections, other provisions, other laws that we can use. They're already there, they're in existence. The prosecution and the police, they can use to regulate crowdfunding activities, even for illegal purposes. Money laundering is becoming more and more common, and therefore it's more cases, if should they arise, the charge will be the appropriate charge. But on the other hand, let me say this before I wrap up my speech. We mustn't confuse the use of such platforms to raise money in order to support that kind of illegal activities, as I've said, with the other kind of fundraising, where, for example, the public is being asked to donate money towards the criminal defense of people arrested for these offenses, or even to support the livelihood of people arrested for these offenses. In those situations, is the dealing with those monies raised money laundering? In my opinion, no. Because every citizen in Hong Kong who is arrested with any offense has a right to receive a fair trial. And people donating to support the legal cause towards defending these people is not chamber tea, because they don't get a share of any winnings back. And it's not for an illegal purpose. It's not a criminal activity. And I would loathe to see that money laundering charges will be used irrespective of for what objective that platform is really raising the money. I find distinction has to be drawn between whether the platform is being used for any legal purpose and whether the platform is being used for a social purpose, which is not illegal. So having said that, I hope that I have instilled into your minds how risky crowdfunding activities can be. And I hope that you have at least gained some knowledge about crowdfunding based on what I have summarized to you. So I thank you very much for your attention. And I'll pass the floor to...
Thank you very much, Joseph. May I invite
Excuse me. May I invite Mr. Anthony Chow to present his speech. And by the way, William, I'll send you a time summon in a few minutes.
Secretary for Justice, distinguished guests, ladies and gentlemen, good afternoon. I'm conscious about time, so I hope I can be as succinct as possible. In this session, I wish to share with you how crowdfunding activities may pose risks to different stakeholders, including contributors, fundraisers, and the crowdfunding platforms, and also wish to suggest possible way to tackle these problems. Now, before going through those issues, let me give you some statistics on crowdfunding. For the crowdfunding activities, we can see in 2021, the global crowdfunding valued for the market, it valued at $12.27 billion US dollars. It is forecast that by the year 2027, it's meant to be a double to $24.54 US dollars at a compound annual growth rate of 11%. So we can see that crowdfunding indeed, especially conducted online, has been a fast evolving sector around the globe. Now, whilst crowdfunding may have a number of advantages, if insufficiently regulated, it will also present risks and problems. Here, may I share with you the 6 potential risks and problems associated with crowdfunding. First, I wish to elaborate about the information asymmetry and lack of transparency problem. And second, we have seen the risk of misrepresentations, the risk of criminal activities, the risk of platform failure or insolvency. And fifth, we have the issue of cybersecurity and the issues of overseas platforms. I hope that in the next 15 minutes or so, I'll briefly go through with you all these 6 issues, and then come up with possible ways to tackle these risks and problems. Now, first, information asymmetry and lack of transparency. For traditional fundraiser activities, such as the issuance of shares by public companies, contributors have access to a company's financial information and statements, and there are a series of reporting requirements under the regulatory regime. The information is audited, rigorously reviewed by professional third parties, and subject to strict regulatory supervision. By contrast, when engaging in crowdfunding activities, we see there are a number of issues arise in relation to fundraisers. For fundraisers, they are not legally required to make available full and accurate information, such as details of the investment project, the profile, and financial information. Without regulations and standard disclosure requirements, it is much more difficult to assess what was happening in those fundraiser companies. And secondly, in terms of the crowdfunding platforms, they, unlike traditional regulated operators, these platforms lack transparency and rarely provide essential information, such as the valuation of an investment, the historic default rates of the fundraisers. Even if the fundraisers have provided certain information, those platforms do not bear any legal obligations to verify the same or through third-party professionals. And as far as the individual contributors are concerned, they are usually a minority in the grand scheme of investment only, and have little bargaining power to make inquiry or request for further information from the fundraisers. They also lack the means or resources to fully verify its accuracy. Worse still, such risk and information may not be fully disclosed to a contributor even after he or she has made a contribution. As a result, contributors may have difficulty in making an informed decisions. Now next, The next problem we have highlighted is the risk of misrepresentations. Given the lack of transparency information, fundraisers can easily make false representations, and any fraudulent activities are difficult to be detected. Such problem is magnified, especially when the crowdfunding activities are carried out online. This is probably first due to the anonymity of internet users. Fraudulent fundraisers can easily change their names with a different email account or divert their IP addresses by using VPN services. It allows them to conceal their identities, to evade investigation or criminal sanctions, or to get rid of a negative reputation or repercussions. And secondly, usually through crowdfunding, funds could be raised more quickly, especially through online, when compared with traditional sources of financing. Therefore, fundraisers may have already absconded with the money before the authorities are alerted, or enforcement action can be taken to stop the funds from being dissipated. And lastly, due to the wide coverage of internet, offers on crowdfunding platforms are made widely accessible to many internet users at the same time. Compared with traditional source of financing, a much larger number of unsophisticated contributors will be involved. It can be difficult for the authorities to investigate and identify all the victims involved. Now, for the third issues or risk that we identify is the risk of criminal activities. As we have heard from Joseph, that there are a number of offenses or crime that can be abused through crowdfunding. And here, if crowdfunding is not regulated, it can easily become the breeding grounds for illegal criminal activities. Crowdfunding platforms may be abused for fraud, money laundering, or even terrorist financing, particularly when platforms escape the regulatory framework for anti-money laundering and counter-terrorist financing. According to a report, Emerging Terrorist Financing Risk, published by the Financial Action Task Force in 2015, quote, crowdfunding websites allow people to easily set up a fundraising page and collection donations. Yet, crowdfunding is vulnerable to exploitation for illicit purposes, including instances where the true purposes of the funding campaign is masked. Individuals and organizations seek to fundraise for terrorism and extremism support may claim to be engaging in legitimate charitable or humanitarian activities and may establish NPO for these purposes. Several cases indicate that the end users of funds collected through crowdfunding and social networks were not known to donors, unquote. Whilst a permit from the authorities is currently required for conducting fundraising activities in public places, as we have heard from Joseph, that this in relation to the summary offense ordinance. Yet, in respect of other kinds of investment or crowdfunding, they are not subject to any direct supervision or specific license requirement. This again may give lawbreakers opportunities to take advantage of the crowdfunding platform to fund illegal activities. In most cases, crowdfunding platform operators lack screening protocol against money laundering or terrorist financing. Before they allow fundraisers to register on their platforms, they are also not required to set up any measures to detect and report suspicious transactions. Hence, platform operators, fundraisers, and contributors may all lack a clear understanding of the resources of funds and are hard to verify the legitimacy of the crowdfunding projects. Now, let me give you some examples concerning the illegal activities of in the pretext of crowdfunding. We have identified the case of HKSAR versus Lam Yunkong, HCMA 749 of 2015. A crowdfunding was used as a pretext for money laundering activities. And in that case, a victim transferred a total of around $236,000 to the appellant's bank accounts. The appellant alleged that he was doing a business of energy products, and through his business partner, he raised funds for investment by way of crowdfunding, and he simply did not know the victims. In dismissing the appeal, the Court of First Instance rejected the appellant's version and held that, having regard to the pattern of the bank transactions, the appellant had reasonable grounds to believe that the money involved was indeed process of crime and that crowdfunding was merely a disguise. I'm sorry, seems to be a technical error here. Maybe I carry on first until the slide come up. Now, well, another example is in the scenario of donation crowdfunding. We have also seen concrete examples showing that it could be used as an aid for terrorist activities. For example, there was a crowdfunding scheme organized under the pretext of collecting donations for Syrian refugees in need of medical and financial aid. Indeed, the funds were sent as an aid to support terrorist activities. Another example, in a terrorist attack in California, leading to 14 people being killed and 22 seriously injured, the perpetrators used the funds obtained from crowdfunding to purchase components for the pipe bombs and over 4,500 rounds of ammunition. Clearly, it can be seen that online crowdfunding activities may increase the risk of crime funding. Next, for the fourth risk that we have identified is the risk of platform failure or insolvency. The crowdfunding platforms may collapse overnight if the platform operators goes bankrupt or the computer system is being hacked, causing the platforms to shut down. When the crowdfunding platforms who act as middlemen collapse, both contributors and fundraisers may bear loss. Due to the lack of transparency, both contributors and fundraisers may be in a difficult position to assess the insolvency risk of platform operators. If the platforms collapse, they lack legal protection against such risk. There's no official compensation or protection of the sums of money they made with the platforms. The said problem are illustrated in the recent collapse of a UK crowdfunding platform, Funding Secure. In the case of Funding Secure, it is a P2P lending platform where individual contributors could lend money to fundraisers who pawned or pledged valuable items such as vintage cars and artworks as securities. In October 2019, after some of its fundraisers failed to repay the loans, Funding Secure became insolvent. Until today, around 3,500 contributors, involving around £80 million outstanding loans, are yet to be recovered. Of course, next we'll hear more from Jonathan Kaplan QC about the experience in the UK about crowdfunding. The demise of Funding Secure plainly demonstrates the problem of information asymmetry. Contributors could not accurately assess the credibility of the fundraisers before making decisions. This may result in a significant loss of investment by a large number of individual contributors. I'm not sure if it's my problem or it's or because of the technical. Oh, thank you. Next is the cybersecurity. Moving on to the fifth problem about cybersecurity. Crowdfunding taking place on the internet is particularly vulnerable to cyber attack, such as overloading a platform's infrastructure, confusing accounts, and identity theft. Unregulated and immature crowdfunding platforms might not have sufficient resources and experience to implement preventive measures and tackle cyber attacks when they happen. Further, personal data privacy is another common concern. a large volume of personal data would be collected in the process of crowdfunding. There's no guarantee against further unauthorized use, transfer, or cross-selling of these personal data for other purposes. Next, overseas platform. These are the issues relating to the platforms incorporated outside Hong Kong. That's the last issue that we have identified. It concerns, since crowdfunding activities are usually done through the internet, platform operators or fundraisers companies are often incorporated outside Hong Kong. It will be difficult for an unsophisticated contributor to identify the governing law and the proper dispute resolution procedures for each crowdfunding transaction. In the event that a crowdfunding investment turns out to be a fraud, contributors may face greater difficulties in tracking down the platform operators or fundraisers and to obtain redress against them. Now, moving on, after we have identified a number of risks and problems involved, we hope to put forward a possible solution. As apparent from the potential risks and problems of crowdfunding activities, we should consider what to do next in order to strike a right balance between facilitating the healthy development of crowdfunding on the one hand and safeguarding the interests of the stakeholder and the general public on the other. One of the possible ways is to enact a new and specific law on regulating crowdfunding in Hong Kong in a more comprehensible way and with respect to its special features. We can make reference to the overseas experience, and based on the overseas experience, the following proposal and suggestions are worthy of considerations. First, imposing licensing registration requirements and ongoing obligations on the platform operators. All online platforms can carry out crowdfunding activities in Hong Kong should be subject to licensing or registration requirement, regardless of their purposes and nature. The crowdfunding platforms are subject to certain due diligence obligations, which include, for example, undertaking background checks on the fundraisers to discover the individuals behind the crowdfunding and the stated purpose of the crowdfunding to verify the credibility of the fundraisers and to filter fraudulent and illegal fundraising activities. Second, it is proposed to subject fundraisers to a continuing duty of disclosure. To address the problem of lack of transparency or information asymmetry, and to reduce the risk of misrepresentation or fraud, all fundraisers should be required to disclose essential information, such as those intended fund usage and financial statements, in a clear and fair manner to contributors on a regular basis. Thirdly, we suggest implement a comprehensive reporting system. A comprehensive system of reporting suspicious activities or crowdfunding platforms should be put in place to serve as a barrier to illegitimate funds raised within Hong Kong being transferred abroad, or conversely, to prevent foreign funds from gaining an easy entry to Hong Kong to fund criminal activities. And fourthly, to set up upper limit of funds raised by a fundraiser. Regardless of the types of funding, the fundraising limits should be imposed on all crowdfunding activities. Of course, these proposals and suggestions are not meant to be exhaustive. They, however, shed light on regulatory possibilities for warding off criminals from exploiting crowdfunding to pursue their illegal activities and advancing the existing legal framework of crowdfunding in Hong Kong. So to conclude, the proper use of crowdfunding activities could certainly benefit the development of our society. However, measures must be taken to tackle the potential risks and problems posed by such innovative form of financing to prevent criminals from turning crowdfunding into crime funding. Thank you very much.
Thank you very much, Anthony. Now, may I invite our last guest, Mr. Jonathan Kaplan, QC, to give us his presentation. Jonathan?
Thank you. Secretary for Justice, Director, distinguished guests and colleagues, I hope you can hear me.
Yes.
I think you can.
Yes, we can hear you.
Good,
Yes, we
thank you.
can.
Thank you. Well, thank you very much indeed for inviting me to join this conference from London, and I'm delighted to do so. And I know the whole day is overrunning, so I'm going to be concise, and I'll be able to say what I want to say about the experience from the United Kingdom and one or two other common law jurisdictions in about 10 minutes or so. I think I begin by saying that the approach in the United Kingdom has essentially been to crowdfunding: be alert, be cautious, but be proportionate. And I suppose there's some parallels between the way we've opened up and treated the COVID pandemic to the way we're treating crowdfunding. And that is an element of proportionality. And I know it's very tempting when we see something new, and crowdfunding is something new, to think, well, we need to design a new law, we need a new statute, we need targeted new specific offences. And of course, that is what happened in relation to pyramid selling. But that actually was very different to the kind of thing we're talking about today. Obviously, it's a different scheme, but that's where there was no genuine underlying business and where the profits came only from money that was generated from new participants. And eventually, of course, a scheme like that is going to collapse because you are going to run out of new participants, and those last in are never going to get their money back. Crowdfunding is altogether different. It is new in the sense that it is using digital technology or fintech to provide an online platform as the intermediary, if you like, for people to donate, to invest, or to lend. And of course, using new technology, using new systems gives rise to different risks, but it is simply a new and different way of raising finance. I think you're all now familiar with the four broad categories of crowdfunding. Broadly, donation, charities; reward funding, when you're buying a small item; peer-to-peer business lending, which is obviously more significant in the sums involved; and equity or investment, which equally is more significant in the sums involved. I think by and large, crowdfunding, which came in probably with donations to charities or urgent, spontaneous, worthwhile causes, has started off with a pretty good reputation. And by and large, I think it has been socially acceptable and well received. In this country, for example, it's also actually been used, not just for individual charitable causes, or let's say for a child who's in urgent need of a kidney transplant, but it's been used actually in major litigation, not in the terms that Joseph has been talking about, champity, where you're seeking a proportion of the damages, but simply to finance litigation of general public importance. And one example was the challenge by a lady, you may have seen it on television, of Gina Miller, who challenged the United Kingdom government over Brexit. Another example is in the case of Queen against Joji, which was the challenge by a family where their son had been convicted on joint enterprise in a murder case, and where the Supreme Court eventually reversed centuries of previous law on joint enterprise, and that was financed and made possible by a crowdfunding exercise. So what is the United Kingdom experience? Well, I think the United Kingdom has recognized that this new financial technology has changed the way in which the financial sector operates. Whether we like it or not, crowdfunding has become an alternative a system of fundraising which has the capacity to help a lot of people who might previously, I suppose, have been termed disadvantaged. By that I mean people who were unable to raise finance because of the banking policies or government policy, small startups that would never have got off the ground, and other situations in which money is needed, but there have been pitfalls or problems to allowing companies or individuals to raise money for legitimate commercial purposes. And I think there's a perception, therefore, that by and large, crowdfunding has filled a gap left by the gap banks and government policy. And it clearly has become, I mean, just looking at the figures that Anthony has showed us, it's become a global phenomenon. And certainly in the United Kingdom, the sums invested have literally doubled in amount almost year on year for the last 8 or so years. And therefore, the approach of the United Kingdom authorities has been not to do anything to end the market, not to do anything to slow its growth, but to regulate it by important but not over heavy touch. And therefore, what that really means is they've sought to develop a proportionate set of rules, and I think the emphasis is on the word proportionate, a proportionate set of rules under which the market can develop and under which consumers are protected. And I think it's right to say that the United Kingdom was one of the first jurisdictions to regulate crowdfunding and recognize it as an alternative way of funding. And this has all largely been done not by acts of parliament, not by the courts, but by and under the watch of the Financial Conduct Authority, who have sought to protect consumers by imposing obligations on the platform operators to ensure transparency and the availability of reliable information. Now, there are only 2 forms of crowdfunding that are regulated here, and this generally is the case throughout the world, as far as I can see. Donation funding and reward funding, where you're buying an item or a service at relatively low cost, are not regulated activities. In the United Kingdom and in most common law jurisdictions, the regulated activities are equity or investment crowdfunding and peer-to-peer business lending. Now, as far as equity investment crowdfunding is concerned, that clearly involves investment and is already within the ambit of most regulators' definition of regulated activity. It is investment. And what the Financial Conduct Authority have done in the United Kingdom is to require platforms to do a number of things. Obviously, to be transparent, to give information, to be authorized. They must be authorized if it's a regulated activity. They must comply with the authority's rules, which are published, and there are rules on crowdfunding activities, which are regularly reviewed. And some of those rules, for example, require them, let's say, to only work with clients who take regulated advice, or if they're not taking regulated advice, then to confirm that they realize the risks of not doing so. Some jurisdictions impose limits on the amount of funds that a consumer can invest. Some impose limits on the amount of funds that a fund can seek to raise by fundraising. So there are all kinds of checks and balances that are inbuilt to authorizing platforms to act as intermediaries in the investment crowdfunding business. What we've done here also is to create a new regulated activity to cover peer-to-peer business lending. And what the Financial Conduct Authority has done is to say that the activity of operating an electronic system in relation to lending, the activity of operating an electronic system in relation to lending online is a new regulated activity. You must be authorized to conduct that, and therefore that too is requires authorization. So we've done it in this country, as have other jurisdictions by and large, by regulation, by looking to the financial regulator. We have not seen it necessary to enact a single piece of legislation to deal with crowdfunding. There are no new statutory offences, as for example with pyramid selling, because prima facie it's not an unlawful activity. We rely on existing common law or statutory offences if an offence should occur. And of course, we've got to be on the lookout for those. And Joseph and Anthony have mentioned them. For example, fraud, mis-selling, money laundering. But we have plenty of weapons in our arsenal to deal with fraud, money laundering, and mis-selling and the like. And I think it's extremely unlikely that there's going to be anything that is arising by way of misconduct or crime that we cannot deal with by existing criminal law. And by the way, I have not seen any statute enacted in any other common law jurisdiction which has created a new offence to deal with money laundering. In Australia, you may have heard of the Corporations Amendment Crowdsourced Funding Act, but that in fact has only made minor amendments to their Securities and Investments Commission Act to in fact reduce regulatory requirements and maintain relevant investor protection measures in Australia. But I haven't seen in New Zealand, in Canada or Australia, any specific new statutory offences to deal with crowdfunding. And to be honest with you, I don't know what they would be, except to reenact existing laws in the context of crowdfunding, which seems unnecessary at the moment. We may be proved wrong, it may be necessary, but that doesn't seem to be the case at the moment. What is necessary is to require authorization and licensing and to impose duties of disclosure and transparency and to minimize the chances of mis-selling on operators and other people that are owning the funds themselves. Now, in the European Union, they've recently introduced, coming into force this month in November, a new regulation, 2021/1503 on European crowdfunding. That does not replace local EU rules if they exist, a local regulation. What it does do is it's directed at assisting businesses in raising finance through online platforms. And again, it doesn't apply to donation, it doesn't apply to reward funding, it applies to lending and investment. And what it's trying to do is to assist platforms to achieve some consistency throughout the European Union. Because there's been different financial regulation within the European Union and the United Kingdom, and indeed other countries, I think it's right to say that there has been divergent treatment on cross-border activity in this area, and that has resulted in a concentration of crowdfunding in a small number of jurisdictions. And one of those is the United Kingdom, which no doubt has proved to be a popular place for crowdfunding. So just stepping back and looking at other common law jurisdictions, and the major ones, or the larger ones, the approach there has been very similar to the UK one. It has been to regulate by licensing and by authorizing. Now, although I've said that's the position, and although I've said there's no specific agenda as far as I can see to legislate, I don't think that should in any sense imply that we should underplay the potential problems. And Anthony indeed has highlighted what those are. I think it is simply an indication of a widespread belief that a combination of the licensing system and the existing criminal law in reserve should be fit for purpose to see us through crowdfunding and the issues it raises. Of course, the important thing is by the moment regulation and licensing to impose obligations on platform operators and fundraisers to ensure that consumers are protected. Now, of course, fraud and mis-selling are going to occur in this activity as they do in any other activity. And that is going to be despite the obligations of due diligence, background check, and disclosure. But if they occur, then I anticipate that the familiar criminal offences with which we're all used to will be deployed. I'm thinking of instances, however, which clearly can arise by crowdfunding, which would not arise otherwise. I've mentioned, for example, that donation crowdfunding is not regulated. Of course, it's always possible, I suppose, to set up, and I'm sure there are many instances of this, a sham charity, which in fact is an illegal enterprise. And to get people to make innumerable small contributions via crowdfunding to this charity as a means of avoiding anti-money laundering measures and as a means of getting funds for use in a criminal enterprise. That's always a possibility. Another possibility, of course, is that you might find such a scheme could fund a terrorist activity or some other illegal activity. Or you might find that an issuer of shares or other financial instruments, which he wants to put into a crowdfunding scheme for the purposes of equity or investment funds to receive those via crowdfunding, you might find that he, in fact, is in collusion with people who have criminal proceeds that they wish to launder, and that he is prepared to swap securities or whatever it is that they're selling for money which directly or indirectly is criminal proceeds as a means of money laundering. All those things may and probably will happen. And the question, therefore, I think then is how we go about imposing on fund operators effectively and proportionately the duty to make suspicious activity reports. It'd be very interesting to know, and I'm afraid I do not, what the number of SARs are from fund operators. Certainly in the investment and in the lending scenarios, you'll be dealing potentially with significant sums, and therefore they should be alert to suspicious activity. In the donation scenario, where you're giving small amounts, obviously it may seem disproportionate if somebody's simply giving $50 or $100 to go through an SAR process. But of course, those can mount up with hundreds of thousands of donations. So I don't know the answer there, but clearly money laundering is a matter which needs to be addressed, and we need to focus on making sure that the SAR regime is adequately imposed and policed in that area. So ladies and gentlemen, that's a brief overview. I think the message is, yes, here in the United Kingdom and in many other jurisdictions, we're not seeking to curtail the market. We're not seeking to close it down. We're seeking to proportionately license it, or we're seeking to license it, and we're seeking to proportionately supervise it and to do whatever we can to ensure that the consumer is protected at every level. Thank you very much.
Thank you, Jonathan. And may I also thank Joseph and Anthony for their presentations. It's already 5:30. I don't think I should occupy this seat anymore. The management might cut the electricity in this theater. So again, thank you very much. And I hope I'll be invited to the Criminal Law Conference in the near future. Thank you very much.
Thank you so much. Thank you. Once again, thank you, Mr. Stephen Ho, and also our speakers, Mr. Jonathan Kaplan-Kilsey, Mr. Joseph Chan, SC, and also Mr. Anthony Chow. Thank you so much, and please be seated. Thank you. We highly appreciate the insightful discussions on what additional steps Hong Kong should take to prevent crowdfunding from becoming crime funding, such as money laundering activities, and address the question of whether, and if so, how Hong Kong should legislate on crowdfunding. For our closing session, we are very honored to have invited Ms. Maggie Yan, Director of Public Prosecutions, Hong Kong SAR, to deliver the closing remarks. Ms. Yan, please.
Secretary for Justice, distinguished guests, colleagues, ladies and gentlemen, on behalf of the Prosecution Division of the Department of Justice, I thank you all for attending the conference. It has been a thought-provoking event, and for that reason, I will not occupy you any longer than is necessary at the end of a long day. I only wish to offer a few remarks about the topics we have discussed today. But first of all, I would like to take the opportunity to thank our moderators and speakers for providing such excellent and inspiring dialogue. There is no doubt that sharing experiences and insights of the challenges leads to new ideas and collaborations. I firmly believe that this conference is one of the most important avenues for us prosecutors to stay abreast of the latest development in different areas of law, whether abroad or in Hong Kong. Our discussion topics today are wide-ranging and are of great interest. We began with a critical appraisal of the importance of human rights in the criminal law context. There was no disagreement between the speakers that the fundamental rights protected by the basic law or the Bill of Rights must be duly respected. The issue, however, is how the court should approach a criminal charge against an individual who commits an offense whilst purportedly exercising his or her human rights. During the discussion, the speakers eloquently highlighted a number of key considerations in such analysis. As our speakers all agree that we have to consider all the relevant factors very carefully in striking a balance between individual rights and the right of others and the interest of the society as a whole. I wish to add that our prosecutors are accustomed to, and in fact required by the prosecution code, to take into account the rights of the accused, such as freedom of speech. In deciding whether or not to prosecute, I will see to it that our prosecutors will continue to recognize the fundamental rights of the accused in each and every case. This is part of our prosecutors' duty to comply with and to promote the rule of law as a minister of justice. For the second topic, the speakers had reviewed some of the principles in Hong Kong which informed how sentencing is to be imposed. This is particularly important in our common law system, where judgment of the high courts bind the lower courts and where the power and duty to sentence is vested in the independent judiciary in the exercise of judicial discretion in accordance with the law. During the discussion, the role of the prosecutor in sentencing was examined. Case law in 1989 suggested that a prosecutor should not attempt by advocacy to influence the courts in regard to sentence, or to say anything that could be taken as advocating severity. Today, there were frank discussions on some of the propositions as to how prosecutors may take up a more active role in order to better assist the courts and to better serve the public interest. We are most grateful for these stimulating ideas from different stakeholders in the criminal justice system. These ideas would help us tremendously in formulating our prosecution policy and practice. On the issue of sentencing counsel, our speakers pointed out that there is already in place adequate machinery to monitor and correct sentences passed by trial judges. The present system is effective. It has been considered that a new mechanism to guide the trial courts on sentencing may not add value to an existing system which is fair, adequate, and working well. The third topic focused on combating corruption in mainland and Hong Kong. We had speakers from different backgrounds to examine the anti-corruption frameworks in different jurisdictions. Such exchange of knowledge and expertise will greatly facilitate regional collaboration in the combat against cross-border corruption. In respect of stepping up Hong Kong's anti-corruption regime, we have heard some practical input from veteran practitioners in this area of law. These inputs reflect the insight not only from a criminal law perspective, but also from a practical investigation angle. Such discussion will be instrumental in consolidating and strengthening Hong Kong's efforts in fighting corruption. Finally, we looked at crowdfunding. Crowdfunding is a dynamically evolving form of financing. Such activity, if abused, could create an avenue for exploitation by criminals to advance their criminal activities. It is therefore unsurprising that there has been suggestion to specifically regulate crowdfunding. Today, our speaker shared with us the development of the regulation on crowdfunding in the United Kingdom. Such overseas experience will surely be useful reference in considering whether crowdfunding should be regulated in Hong Kong. And so, if so, how? As our speaker pointed out, that there is a lack of direct and comprehensive regulatory regime on crowdfunding in Hong Kong. In view of all the risks and problems highlighted by our speakers, there seems to be a need to take new measures to regulate crowdfunding in Hong Kong. Just like many other countries, measures must be taken to ensure that crowdfunding would not turn into crime funding by the criminals. Our department will pass on all the insightful sharings by the speakers to the relevant policy bureau so that they can consider how best to regulate crowdfunding activities effectively in order to protect the public from being exploited by the criminals. Once again, I would like to thank our moderators and speakers for their insightful sharing. And I thank you all for participating in this remarkable conference. I very much hope that you have all found it informative and stimulating. On this note, I declare the conference closed. May I thank the organizers of the conference and all the supporting staff for making this event a very successful one. Thank you.
Thank you so much, Ms. Yan. Thank you very much. Today is such a good day and insightful day. I believe you all gained so much, not only knowledge, but also insight. To all our participants here and watching this live broadcast, thank you so much for joining the International Criminal Law Conference. We will have more programs in the coming few days. Please do join us together and make reservation on the official website, legalweek2021.hk. Thank you and have a good day.